Good morning again. Before we get started today, I'm going to ask Mr. Jeremy Cummins to open us up to the word of prayer.
Let's pray. Father God, we thank you for a new day, and we thank you for all the blessings of life, and we ask you to forgive us where we failed you. Lead and guide us today. Help us as we make good decisions to God. Help us to think clearly. We pray for calm nerves and just a good day. We ask this in your name. Amen.
Thank you, Jeremy. We are ready to go on the record. The Mississippi Board of Nursing is made up of 13 members, 7 RNs, 4 LPNs, and 1 physician and a consumer member. Today, you have a member of 4. Of the full board, 3 will serve on the panel and 1 as an alternate. I will start off with introducing the panel today, starting to my right.
Janelle Moody, RN.
Nancy Holmes Johnson. Dr. Melissa King, nurse practitioner.
Jeremy Cummins.
And good morning. I am Kristen Love, the hearing officer for today's hearing, Special Assistant Attorney General from the Mississippi Attorney General's Office. And with me today is Attorney Shelley Amos. Recently joined our office, and hope y'all will see more of her, or maybe not.
Good hearing. Yes, I hope to be here more. I don't know that they either.
Ready, I will call up the first matter on the docket. Case number 2021-0351 and 2023-1138. The licensee is Ms. Holly Lovett, license number R-880652. And I am Kristen Love, and I will serve as the hearing officer in this matter today. My role during the course of this proceeding will be to rule on objections to questions or evidence raised by the parties, to see to the orderly process of the proceedings, and to ensure that the proceedings are conducted in accordance with the applicable laws and rules. The members of the board have stated their names for the record. And now I ask the attorney representing the board to state your name for the record.
Deanne Salzman.
And is the licensee Ms. Holly Lovett present?
Yes, ma'am.
And Ms. Lovett, are you represented by counsel?
No, ma'am.
Because you're not represented by counsel, I have a few questions for you. You understand you have the right to have an attorney represent you during this matter today?
Yes, ma'am.
And you understand you have the right to have witnesses testify on your behalf?
Yes, ma'am.
And you understand you have the right to have subpoenas issued by this board on your behalf?
Yes, ma'am.
And do you understand the nature of the charges pending against you such that the outcome of this hearing could be revocation of your license?
Yes, ma'am.
Understanding all of that, do you wish hearing without an attorney?
I do.
Now I want to identify the individuals in attendance that will give testimony today.
The board will call investigator Tawanda Jones.
Brother Jones and Ms. Lovett, will you testify on your behalf today?
Yes, ma'am.
So I'm going to ask the court reporter here she's transcribing this proceeding. She's going to swear y'all in.
Raise your right hand. Do you solemnly swear or affirm that the testimony about to give today will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
I do.
Are there any preliminary matters?
Yes, Your Honor. The board would request that exhibits B1 through B24 be entered into evidence today.
Ms. Lovett, do you have any objection to the admission of those exhibits?
No, ma'am.
The board's exhibits are admitted into today's record. All right, we'll proceed as follows. We'll have opening statements and argument side, allows questioning, and at the conclusion of the presentation of both parties, Councilman, if you're ready to proceed, you may begin now with your opening statement.
Thank you, Your Honor. Mrs. Lovett was first licensed as an RN in Mississippi in 2008. In 2013, she entered into an agreed order with this board arising from misappropriation of drugs. Today, we are here for a hearing before the board panel related to 2 separate complaints that have been made. The first allegation is that Mrs. Lovett did an override and pulled a narcotic from the Pyxis machine while she worked at Rush Hospital Meridian on February the 2nd, 2021, and then left the hospital early after she had been flagged for monitoring due to narcotic usage. More recently, on December the 2nd, 2023, while she was working as a nurse for Queen City Nursing Home in Meridian, it is alleged that she was witnessed by coworkers falling asleep while standing and in front of the computer. She submitted to a reasonable suspicion drug screen that resulted as positive for cocaine and THC, in addition to those drugs for which she had valid prescriptions. Later that same day, she submitted to a drug screen that did not show as positive for cocaine and THC. Today, it is alleged that Mrs. Lovett misappropriated drugs and she practiced the profession while impaired by authorized medications. Thank you.
Start.
Optional, but it's just a brief, very brief overview of
Um,
your case that you plan to.
the first case, that she is, discussing, about overriding medications and, then leaving the hospital early and those matters. Those matters are not true. There is documentation that it was a witnessed waste from the facility. There is, documentation of that. There is also documentation through the main Oshner facility that we were on override at that time, and we had to override every medication at that time. The only way that I could get those records subpoenaed was through y'all. And I just found that out like Friday. That the only way that I can get a copy of those records is y'all subpoenaing them from the main Rush hospital, main Oshner. Oshner and Rush were transitioning together at that time. And I was helping float out in the area and pulled the wrong medicine on the wrong page. We were learning the new system too. And me and another nurse, her name's Carly, we went and she opened the vials and we wasted the medications. And there's a video in there also, but they told me that the video camera didn't work when I spoke with the pharmacy. Pharmacy's name is Miss Rita, and she is who I spoke with, that did state that it is a documented override time. It is documented waste, and it does show that the nurse that wasted with me was her patient, and she can tell you that the order was wasted. And then also that there was not an order in because the patient's family left, like their driver left, and so there was no need for the medication. So we did not re-pull the medication.
Thank you, Ms. Lovett, for your openness. Ms. Hausman, at this time, if you're ready to begin with your case, you may call your first witness.
The board calls investigator Tawanda Jones. Please state your name, county of residence, and place of employment for the record.
Tawanda Jones, county of residency is Rankin County, employed with the Mississippi Board of Nursing,
How long have you worked for the Board of Nursing?
6 years.
And during that time, you've participated in investigations that result in the discipline of licensees?
Yes,
And is it part of your duties with the board to investigate complaints that are received related to individuals licensed by this board to practice nursing in the state?
yes.
If you would please turn to page 5, which is marked as Exhibit B3, and identify this document, please.
Page 5, Exhibit B3 is a license verification for the respondent.
What's the license number?
License number 880652,
And what's the license type?
registered nurse,
And what's the current status of that license?
active.
And when was the license first issued?
The license was first issued August 21, 2008.
And when does it expire?
The license expired on December 31st, 2024.
If you would please turn to page 12 of Exhibit B5 and identify this document, please.
Page 12 is amended notice of hearing.
And if you would, could you tell us what date Mrs. Lovett was ordered to be present before the board?
Monday, April 8th, 2024.
And is Ms. Lovett in fact present today?
She is.
And in this notice of hearing, was Mrs. Lovett told that she could request subpoenas?
Yes.
Was she also told that she could call witnesses as well?
Yes.
If you would, please turn to the second page, page 13, and identify this document.
Page 13 is the amended complaint.
And what are the charges against Mrs. Lovett today?
Charge 1 is violated Mississippi Code annotated 73-1529L1, and the respondent engaged in an unprofessional conduct as identified by the board and its rules, namely misappropriation of drugs, supplies, or equipment in violation of 30 Mississippi Administrative Code PT 2820 R1.2H. Charge 2, the respondent violated Mississippi Code annotated 73-1529L1 in that the respondent engaged in unprofessional conduct as identified by the board and its rules, namely practicing the profession while under the influence of alcohol or other mood-altering substance as evident by impairment while on duty, while using authorized or unauthorized medication in violation of 30 Mississippi Administrative Code PT 2820 R1.2 F3.
And if you would, please tell us what additional facts are listed in the complaint to support these charges.
The respondent was employed as a trauma coordinator at Rush Hospital in Meridian, Mississippi. On or about February 2nd, 2021, the respondent was instructed by her instructor not to pull any narcotics from the Pixie machine because the respondent had been flagged for monitoring due to narcotic usage. On or about March 24th, 2021, the respondent did an override and pulled a narcotic, Demerol 25 milligrams ml injection from the Pixie machine without a valid order. The respondent then left the facility without checking out. On or about December 2nd, 2023, the respondent reported to orientation at Queen City Nursing Center in Meridian, Mississippi, and was witnessed by coworkers falling asleep while standing and falling asleep while logging into the computer. The respondent was asked to submit to a reasonable suspicion in-house drug screen that resulted as positive for cocaine, oxycodone, amphetamines, and benzos, and THC. The respondent immediately obtained a drug screen from her primary care provider that resulted as prescription positive for amphetamines, benzos, and oxycodone.
Thank you. And if you would turn to page 15 and identify what this document is as well.
Page 15 is a receipt for certified mail addressed to Ms. Lovett.
And did she sign showing that she had received a copy of the notice of hearing and complaint?
She did.
Okay, we're gonna start with the Queen City Nursing Home incident in December. Go into the most recent case first. What did your investigation show related to this complaint made against Mrs. Lovett?
The complaint made against Ms. Lovett at Queen City Nursing Home was that she was on duty, and while on duty, she was falling asleep at the computer. In addition to falling asleep at the computer, she was standing in the room while her supervisor was trying to give her instructions, and she was falling asleep, and she was asked for a drug screen, and she tested positive for a drug screen on that day.
If you would, please turn to what's been marked as page 19, and that's Exhibit B7. And identify what this document is.
B7 is a statement from, you don't want me to call her name.
That's okay. You can call her name.
Okay, it's a statement from Michelle Daniels, LPN.
And does it have a date?
It does have a date.
And what's that date?
The date that this document was signed was December 4th, 2023.
And what does this statement indicate for Mrs. Daniels related to Mrs. Lovett?
This is a summary of what happened on the date of the incident, and at the end to the left of the statement, it shows what she was positive for the in-house drug screen.
And does this discuss her falling asleep at the desk?
It does.
If you would, please turn to page 20 and identify that document.
Page 20 is another witness statement provided regarding the incident by an RN.
And in the upper right corner, what's the date of this statement?
December 2nd, 2023.
And if you could, again, just kind of summarize what this statement tells us.
This is a person that said that they noticed that the respondent appeared drowsy. She was asked what needed to be done. She explained to her what they were going to do, and she went with her to a room. And in the room, while she was explaining the medical history for that particular patient, she was found standing asleep. Keep it.
That's fine. And if you would turn to page 22, that's been marked as Exhibit B8 and identify that document, please.
Exhibit B8 on page 22 is Queen City Nursing Center Employment Termination Report.
And what's the termination date?
Termination date is 12/2/2023.
And who is the employee listed on this termination report?
The respondent.
And what's the last day that she worked?
Last date work was 12/2/23.
And does it list the basis for the termination?
Yes.
Could you read that to us, please?
RN unable to perform duties of orientation under RN supervisor, discussion with RN reports had drug screened within hours of leaving facility on 12/4/23. Will add to nurse report.
If you would, please turn to page 23 and identify that document, please. That's Exhibit B9.
Exhibit B9, page 23 is a chain of custody for the respondent.
And what does this show?
The specimen was received from the respondent on 12/2/23. Michelle Daniels, LPN, QA, and Jessica Hawkins, RN, reviewed the results. The specimen locked in the QA office, and Joanne Hawkins, the DON, received the specimen.
And if you would, in looking at pages 25 through 26, were those results also attached to that chain of custody form?
These are just pictures of the in-house drug screen.
You would please turn to page 27 and identify that document, please.
Page 27, B10 is a medical record for the respondent.
And what is the date of this visit?
The date of the outpatient visit is 12/2/2023.
And that's the same day that she took the drug screen at Queen City, is that correct?
That's correct.
Okay, if you would go maybe halfway through the interim events and start with, she was given a urine screen. And read that to us, please.
Okay, halfway through paragraph 1 is she was given a urine drug screen at Queen City, which resulted positive for THC, amphetamines, oxycodone, and cocaine. She is insistent that she does not smoke weed or never has used cocaine.
And you can stop there. If you would turn to page 29 of that same report. And was a drug screen conducted with this provider?
Yes,
And what were the results for that drug screen as shown on page 29?
okay, on 12/2/2023, she was positive for amphetamines. On 12/2/2023, she was positive for benzos. And on 12/2/23, she was positive for oxycodone.
What does it say related to cocaine?
Cocaine is positive.
Mm.
Negative, I'm sorry.
And what does it say related to THC?
THC is negative for 2/2/2023.
Thank you. Please turn to page 20. I'm sorry. So just to be clear, what did she test positive for that day? Amphetamines, benzos, and oxy, is that correct?
That's correct.
Did your investigation show that Mrs. Lovett appeared impaired
It does.
while she was on duty at Queen City?
Yes.
And does this report indicate the cause or a possible cause of her impairment on page 29? I believe if we look at the second paragraph under the drug screen towards the end. It says this is consistent with, starting there.
Okay, starting with that sentence, this is consistent with her previous drug screens. It is highly likely that she was drowsy at work due to change in anxiety and insomnia medications, which were made at her last appointment on November 22nd, 2023. Continue.
Just finish out that.
Okay, this is a compound by the fact that she has been out of work for a few months while she dealt with issues from dissolving of her marriage, childcare, and other extreme issues.
So either way, whether the drugs that she were on that day were authorized or unauthorized, did your investigation determine that she was practicing nursing while she was impaired,
Yes.
as evidenced by her standing and falling asleep? Okay, let's go to Rush Hospital. Allegations from March of 2021. If you would turn to page 60, which is Exhibit B20, and identify that document for us, please.
Okay, B20, page 60 is a termination report for the respondent.
And does it show her hire date?
Yes,
And what was that?
her hire date was March 16th, 2017.
And what was her last day worked?
Last day work was 3/24/2021.
And what was the date of her termination?
Date of termination, March 25th, 2021.
And was this termination requested by the hospital?
Yes.
If you would, please turn to page 61 and tell us what's listed under number 17, breach of hospital rules.
Number 17, breach of hospital rule. Yes. Compliance breach. Pool narcotic on 3/24/2021.
And please tell us what's listed under number 18, refuse to follow instructions.
Number 18 is yes, instructed on 2/2/2021 not to pull any narcotics from the Pixie.
And if you would, please tell us, the board panel, what's listed under the details section regarding termination.
Holly has been instructed on 2/2/21 not to pull narcotics from the Pixie. It was reported on 3/24/2021. She removed Demerol 25 and Zofran. The pharmacy report shows 10 times. Holly removed the scheduled drugs in clear violation of her instructions on 2/21/2021. Holly was requested to come in for a conference on 3/25/2021 to Human Resources to discuss the event. She did not show for the conference, but sent an email to Leslie Sanders, copy to HR stating she resigned immediately. Assistance was offered but refused. Holly stated that she did not need any assistance. I cannot recommend Holly for another position currently.
You would please turn to page 65, and this is Exhibit B22. And if you would, and let me go back, Your Honor, could I request that the exhibits here be sealed because they do contain patient information?
Okay, Miss.
To everything we've gone over so far.
Just her request. Still, forward exhibits.
No, that's fine.
And if you would, Mrs. Jones, if you would refer to all patients with initials. And if you could identify Exhibit B22 for us on page 65.
Exhibit B22 is a time card for the respondent.
Hmm.
Okay. I'm sorry. This is an event detail report for the respondent.
Okay, so this all device events report, is this for patient JS?
Correct.
Okay, and could you tell us what this document shows?
Okay, on the first line, it says verify inventory on 3/24/2021, and it gives the time. It says 8 valves. And then on override on 3/24, 2 valves. And then there was a waste on documented as a waste on 3/24/2021. And the user is a respondent.
And if you would, if you look at that first line on this report, is it referencing Demerol? Is that
Yes.
the drug that's being pulled?
Yes,
And if you look at the override, it went from beginning of 8 to ending of what?
2.
How does it end? What's the number that it ends with?
Oh, 6.
The 2 were pulled,
2 were pulled.
and who is the nurse's name that made this pull?
Holly Lovett,
For patient JS.
yes.
Oh, no.
So, in looking at this, just so we're clear, it appears that Ms. Levitt verified inventory at 10:49 a.m.
That's correct,
and then she did an override 2 seconds later,
correct,
pulled 2 vials of Demerol,
correct.
and then it shows a waste of 50 milligrams at 3:24.
On 3/24, correct.
Does waste require witness signature?
Yes.
You would turn to page 66 and identify that document, please.
Page 66, B23 is the medical record for the patient.
And if you would, can you tell us what medications were ordered on page 69 of this report for this particular patient? And this is patient JS, correct?
That's correct. Page 69, there were no medications ordered for that particular patient.
So these medications were pulled for a patient that didn't have orders for Demerol, is that correct?
That's correct.
You would turn to page 71 and identify that document, please.
This is a report from pharmacy.
Okay, and what does this report show?
It shows that Demerol 25 milligrams was, the cabinet override was by Holly Lovett.
And is that for patient JS?
That is for patient JS.
And does it also show it's returned at 10:55?
It does.
But what is the note there?
The note says that it did not find the medication in the return bin.
And what happened after, with Miss Levitt after that she pulled that Demerol?
Once she pulled that Demerol, she left the facility without checking out and letting anyone know.
Let's go back to page 57, which is exhibit B18. If you could identify that document, please.
B18, page 57 is the timesheet for Miss Lovett.
And can you tell me the clock in and clock out times for 324?
Clock in time is 6:54. Clock out time is 11:04.
13.
You say that one more time.
Clock in, it looks like a 6:54. And clock out at, maybe that's a 13:04.
1304. And if you would, please look at the next page. Page 58, and it's exhibit B19. Could you identify that document, please?
This is a note in the time clock out sheet by Leslie Sanders indicating that on 4/1/2021, she made a note that the respondent texted and said that she had to leave to pick up her sick child. So that note was added into the file as to why she did not check out on the date of the incident.
And if you would, please turn to the next page, page 59, and what is listed there. Identify this as well.
Page 59 is dated 4/5/21, and it was modified by Leslie Sanders for Holly Lovett. And it says on 4/1/2021, a
59.
clocking for employee Holly Lovett was added and modified by Leslie Sanders.
So is it Ms. Sanders who clocked Ms. Lovett out at 13:04?
Yes.
If you would, please turn to Exhibit B16, which is on page 46, and identify what these documents are as well.
B16 are text messages between Ms. Lovett and Leslie
And if you
Sanders.
would, let's just read through some of those text messages. Would you, are these for Wednesday, March 24th of 2021?
Yes.
And what basically is she saying is the reason for her leaving so abruptly from the hospital?
Okay, the Sanders is saying you need to return immediately to the department. And then the respondent says, okay, I'm picking up LG, then I will. And then she texts again at 1:26. I'm trying to figure out what to do with Lily Grace. She has fever and vomiting. At 2:08, still trying to figure out someone available to get her. And then at 6:02 PM, couldn't find anyone to keep her. Her temp was 102.6. She vomited and had explosive diarrhea in her car seat when I picked her up. Just let me know what you need me to do.
That's good, but these are text messages to provide to you from Mrs. Sanders during your investigation.
Correct.
And if you would, please turn to page 53, Exhibit B17, and identify that document.
B17 are emails between Ms. Lovett and myself. And then you want me reading?
No, well, let's go back to halfway through the page. So that first email is between you and Mrs. Lovett, correct?
Correct.
And these are emails that she sent to you during your investigation, correct?
That's correct.
And these emails involve conversations between Mrs. Lovett and who else?
Leslie Sanders.
And if we go back to the beginning of this chain on page 55, what does Mrs. Lovett tell Mrs. Sanders?
This is Leslie. I wanted to send you an email that included the text message that I sent to you on your phone tonight on March 24th. I have been thinking about our phone conversation earlier. I spoke with my husband as you asked me to do so. I do not have anyone to keep my child in the morning. And then from the conversation that we had on the phone, it sounds as though I'm being called to be terminated. I know for a fact that I'm confident that I did not do anything wrong other than leaving without clocking out because I had to go get Lily Grace. Keep going.
No, that's enough. So did she ultimately resign
Yes,
and she doesn't return to the facility? Is that correct?
that's correct.
If you would, please look at page 44, which is Exhibit B15. And identify this document as well.
Page 44B15 is an email statement that Ms. Lovett gave to me,
On what date?
March 10th, 2021.
I'm just going to point your attention to the 5th paragraph. If you read that 5th paragraph, please.
That day, I did not have patient assignments. I was not in the rotation of patient care. I was just doing whatever was asked to help. Since this was the first week of Epic rollout and overwhelming.
And then if you go to the next paragraph and read those first two sentences as well.
The way the medication was pulled without an MD order in the Pixies is because no orders put in at that time were crossing over. Keep going. Every single medication from triple antibiotic to IV fluids, Tylenol, no matter what, had to be overwritten.
Thank you. So she provided in her statement to you that she was not in the rotation of patient care at the time the Demerol pull occurred. Is that correct?
That's correct.
But her explanation related to the override was what?
because things were not crossing over.
And if you would, turn into the second part of her statement, the third paragraph from the end that says, I did not intend. What does she say related to her leaving without clocking out?
She says, I did not intend to leave without clocking out. There's a text message to Leslie telling her I was leaving since I tried to call her, but she did not answer the phone.
Are you aware of whether Mrs. Lovett has had prior discipline with this board?
I am.
If you would turn to page 34 and identify that document, please.
Page 34 is a final board order for the respondent.
Could you tell us the date of this order by looking at the end of the order on page 42?
The order was entered, approved and accepted on October 4th, 2013.
And going back to page 35 of this order, what was the basis at that time for discipline related to Mrs. Lovett? I believe it's in paragraph 3.
Paragraph 3. The respondent engaged in unprofessional conduct as identified by the board in its rule, namely Mississippi Administrative Code 2820 R 1.2 in that the respondent misappropriated drugs, supplies, or equipment.
And what were the facts that supported that charge?
The respondent admitted in her written statement to the board that she injected Dilaudid 1 milligram to herself instead of wasting said medication while on duty at Anderson Regional Medical Center.
If you would please turn to B14, which is on page 43, and identify that document.
B14, page 43 is a stipulation removal letter from the Mississippi Board of Nursing.
So Mrs. Lovett had stipulations removed related to that 2013 discipline?
That's correct.
Okay. And if you would, please turn to Exhibit B24, which is found on page 72, and identify this document.
Page 72 is a PMP for the respondent.
And what is a PMP?
This is a list of all narcotics that were prescribed for the respondent for a time frame of 3/21/2021 through 3/21/2024.
Now, if you would, prior to December of 2023, when was the last time Mrs. Lovett had been prescribed oxycodone?
There's an oxycodone listed for 3/3/2023.
And how many days was that script for?
2.
How many days was that script for on 10/3/23?
10/3.
Yes.
For 10/3/2023, oxycodone was a 3-day supply.
So she tested positive in December for oxycodone, correct?
That's correct.
And the last prescription that she had for oxycodone was on October
October 3rd,
of 23,
correct.
and that was for 3 days. Is that
Correct.
correct?
Yes.
No further questions.
Any questions from the board for this witness? Ms. Lovett, do you have any questions?
I don't have questions, but I do have stuff to say in regards to.
Reserve your response. for-
Okay.
It's your turn.
I do, with the oxycodone prescription, did we get, a, record or anything from the providing physician that had written that prescription? Or was that for me to get?
No, I did not get anything. I just have the PMP.
Okay, okay. That's all I needed.
Any, redirect, Ms. Thompson?
No, Your Honor. I do. Thank you.
Rest at this time.
Yes, Your Honor.
Ms. Lovett? Stop moving now to say your defense to the charges pending the issue.
All right. So I'm gonna, which case did we start with? The Anderson?
You can start with whatever you want.
Okay. I'm gonna go on and start with the, can y'all hear me okay? I'm gonna start with the Queen City, nursing home case. And it looks like that is going to be, let's see. B9, that's gonna be page 3727. All right. Actually, I'm gonna go to B7, I'm sorry, and I'm gonna go at, that's gonna be page 19. If you read the note, this is a nurse that had gotten supposedly called in for this action. But if you look at the time that the note was written by the other nurse on the next page, she is saying that at 7:30, when I got to work, I noticed Holly appeared drowsy. She asked what needed to be done. That was me asking her hey, what do you need me to do? This was my first day of orientation. We had just changed my medication of Remeron. They had increased it. I was going through a divorce, a very bad divorce, with a lot of abuse, child custody arguments, all of the above, So, anyway, I'd asked her what it needed to be done. The computer went dead on me and I was sitting there, nobody was up. And I never told her that I didn't get enough sleep the night before, that I needed caffeine. I told her, I made it very clear that my medication dosage had been adjusted and that I'm sorry if I was groggy once I got up and moving, I was going to be, I would be more functional. But then going back to where Michelle on page 19 of B7 noted that she received a call that I was stating that I was asleep at the desk. Not one time was I asleep, and that facility has cameras throughout. So they could have given the video camera, of that. When it said I was unable to urinate for 2 hours, back in March of that year, I had upper pole neoplasm in the left kidney, and I have had operations since then. So it does take me a little longer to void than it typically does a normal person. With that being said, I also, the whole time that I was sitting in the room with Michelle, we had regular conversation. We were talking just like we are now. I was never impaired in front of her. I would never put a patient in harm by being impaired in a patient's room. Also, she said that I urinated very little in a cup because I urinate very little with said history. But I did. They did not, once the urine was obtained, they left it in the bathroom. I had to sit out at a table and both of them went into the bathroom, looked at the sample and then came out. So I didn't get to see the sample be unavailed to open where it shows what you're positive or negative for. I didn't get to see any of that. But immediately I knew that I had not taken anything because I'm not back in 2013, I made a terrible mistake, and I have made it a point to let students know a one-time mistake will follow you for the rest of your life with the board, when I precept in the ER and that type of stuff. But it also is showing that, that I said I didn't feel comfortable taking a drug screen. I never had said I did not feel comfortable taking a drug screen. I will take a drug screen any day asked. Then they put me on a bus, and sent me to Workforce Wellness on a Saturday, which they knew was closed. Well, I knew that my provider is in office on Saturdays from 8 to 12 doing documentation. And so that is when I called and got in touch with the provider and went straight to the clinic and was retested. If you look at the time from the retest results and the time I got to the clinic from the time I left that facility, there was no time in between. I mean, I went from there to the clinic to be retested. Also, I feel like that the urine and the results that they turned me in on is premature due to the fact that I never got a secondary test, a confirmation test. A doctor never saw the first test to even be turned in. A physician didn't sign off on that test. And then it shows that they terminated me for cause. No, I went in that Monday as Miss Joanne had told Michelle for me to do. Miss Joanne is the director of nursing. That entire day, I forgot to bring my medical records with me. She would not answer my phone call from the time that this started until would not answer my phone call. And so I will get my phone records, and get those turned in so y'all can see that. I'm sorry I did not bring that today. This is just very overwhelming. But with that being said, she states that I'm unable to perform duties of orientation under the RN supervision. Yet the day prior to that, if you look on my timesheet that I was there, she was looking and wanting me to take her position when she left. So we're dealing on two different ends, of an issue here. I had not tolerated the medication adjustment well. I had a lot personally going on in my life. And that's really all I can say about that. I went that Monday to give her the results from the clinician. The state was there, and she told me to leave and come back on Thursday. So I still never was offered a secondary test, which typically and in policies, we're supposed to be offered a secondary test if you have a positive screening. And that is to verify and then to send off also, which was not done. There was no confirmation testing on this. Now, there are any other, if you look at 11:15 is when I clocked out. And then these results, I don't even know why sorry, I can read that. Let's see if it shows what times I got to the clinic, because I went straight there. I'm sorry, but it doesn't. But if you do look on page 27, B10, I am going to I'm sorry, page 29. If y'all will take a look at the second paragraph underneath the drug screen that are actually on the status progress. Based on the examination today, my problems are adequate but not ideally controlled. New problems have been presented, comorbidities, diagnostic uncertainty. But then under general impression, at this clinic, she has been drug screened every 3 months, as is protocol, due to being prescribed controlled substances, and her last drug screen prior to today was 9/28. She has never tested positive for anything which she was not prescribed. That right there, I have been seeing that provider since 2001. I believe it is a mental health nurse, mental health practitioner. And that is who I see. And I have never tested positive. And I will sometimes get random screens in there too, in between. And if you look down, there's my diagnoses. If you look further down, I, would rather not call that out loud, but, so with that, that's, I think, is there any questions that I,
Now, Ms. Sampson may have some questions.
Ms. Levitt, could you tell the board your educational background?
in 2008, I became a registered nurse. In 2017, I got my bachelor's. I am currently looking at getting my master's in nursing education and also mental health nurse practitioner at the W. I am a sexual assault nurse examiner, adult and pediatric. I have roughly 100 certifications. I'm certified all the way through FEMA, from FEMA 100 through FEMA 980 something. I don't know. I've ACLS, PALS, BLS, TNCC, EMPC. I take it upon myself to really and truly try to do better and be a better person and to make other nurses want to be better. When I was working in the ER and I was precepting nurses, I would always tell them and educate them on the mistake that I made back years ago and tell them that, you always hear in nursing school, one mistake follows you for the rest of your life. It really does. Every job application that I go to, I just go on and tell them, like, I made a very big poor decision. This is what happened. And I go on and tell them up front, because it really does follow you. And then it looks bad under implications like this when you truly are innocent, which is the reason I'm here. I should have, I guess, brought an attorney. Everybody else did, but I came by myself because I am innocent. I have no desire to do wrong. I have no desire to be altered or go to work altered. I won't.
Ms. Levitt, could you tell us where you currently work?
Right now, I'm currently doing online nursing and EMT tutoring from home. I forgot I was a EMT too. But I currently do private tutoring from home right now, and I was actually got called for a job just the other day, but I'm waiting on this. So
Private tutoring from home online?
yes, ma'am.
What company is that?
Super Pro.
Super Pro?
Yes, ma'am.
How long have you been there?
I've been doing that since December of 23.
And we know in December of 23, you were at Queen City, correct?
For like a week.
You before that?
um, Golden Living, and that was in May.
Building living facility?
Yes, ma'am.
Is that a long-term care facility?
Yes, ma'am.
And you worked there in May of 2023?
Yeah, April and May. Like I had the issue in February, March, and then April or May is when I was at Golden Living Center.
You said you had the issue in February and March of 2023.
Mhm.
What issue?
The neoplasm of the renal pole.
So you weren't working in February and March of 2020?
No, I had to take off. Yes, ma'am.
And then you went to work at Golden Living
Yes, ma'am.
from April to May of 2023.
Correct.
Where did you work from May through December of 2023?
I took off. I got put back in the hospital and that's why they had to let me go. I had an ileus and a potassium of 2.2 and a spot in my brain that we are still monitoring.
Where did you work in 2022?
My memory's poor. I have my resume in front of me. I got the preserve at Meridian, opened. I spearheaded, the preserve at Meridian. It is a, long-term, it is a resort style assisted living facility. It has 28 independent cottages, 69 regular rooms and 28 memory care rooms.
So how long were you working for the preserve?
I worked there I went in just to get it open. So from like May, and then we got licensed in October. They came back within 2 weeks. I stayed through December to make sure we got the full licensure. And then I took time off to be with my family. And then that's when things just went downhill.
Where were you before the preserve?
I did home health.
With who?
We had Kindred at home.
I'm
sorry, Kindred at home. Mhm.
And how long were you there? That would have been, I assume, sometime before May of
It was
2022.
it was right after I left. Yeah, it was like, let's see, because I had a bad wreck in 21, in December of 21 there. So I was there then. It was after I left Rush. I left Rush and went there.
You referenced your prior discipline with this board. Could you tell us the circumstances surrounding that prior discipline in 2013?
We had a patient that came in and it was half a milligram of gelato we were going to waste, and I have a hearing malformation, had a really bad headache, and oh, you can't hear me. I'm sorry. Had a really bad migraine, and the physician on actually knew, and I told them back in that day that he knew about it. I just wasn't checked in as a patient. Took a shot, and my spouse then came and drove me home so that I could try to sleep off the headache. But I've worked with Rush / Ochsner now since 2014, and I've never even had a coaching. I have never gotten in trouble. I have never, nothing. I've never had any type of issue at all.
Are you saying that that was a one-time event in 2013?
Yes.
You ever attended any type of treatment program?
What do you mean?
Addiction?
Oh, no, they made me get tested and I'm not, no,
So you don't have a sobriety date?
no. I don't have an addiction. I don't drink or anything. Like, nothing.
You testified previously that you were not asleep at Queen City. Is that correct?
That is correct. I was groggy.
So the statements from Ms. Daniels and the statements found in B7 and B8, those are incorrect when they say that you were asleep.
Yes, ma'am, and I would argue that if I was able to, yes.
And then in the provider report that's on page 27, they discuss, or on page 29 specifically, that it's highly likely that she was drowsy at work due to changes in anxiety and insomnia medications.
Correct.
But you still contend that you were not asleep that day. You were only drowsy.
No, I was groggy. Like the whole time I sat there to take that urine drug screen, I was having a conversation just like we are right now.
Do you feel that you were safe to practice nursing on that day in that drowsy state?
I was only drowsy when I was sitting there with a computer that wouldn't work and I had nobody sitting around me talking. Like it was in a dark room. It was in just a computer. The computer was restarting and I had to re-input my password, change my password. And I was sitting there and I was groggy. Also I don't know how you fall asleep standing up. I'm sorry. I don't have the will to do that. Or I don't have the ability. I've never done that.
And tell me again, if you weren't involved in patient care in 2021, why you were pulling anything from the Pyxis machine?
This is when we were doing the Epic. We were having an Epic rollout. It was that week of Epic rollout. We had number one just changed from Omnicell to Pyxis or one to the other. And then they did the Epic rollout. That was the week of Epic rollout in the ER. And when I went into my office that day, and all of that is documented to Leslie, they had like 5 computers in my office and none of them were working, which is documented in my report. That none of the state registries were documented, my trauma registry. That is,
Let me ask this a different way. Why did you feel Demerol on that day?
I was floating. I start with one nurse. When I couldn't do my job that day, I get told, well, you can come out and you float. So I got patient on monitors. I would go get urines or labs, transport to the, x-ray. And one of the doctors had gone and seen a patient. And the nurse, I was standing there and I was moving to her actually. And I stood there and I was listening as the doctor was talking to her. And he told her, he said, we're going to get an IV on them. Let's pull some labs. We're going to give them the Demerol, Zofran, and normal saline. And I said, okay, well, do you want me to go start your lab or do you want me to pull the meds? And she said, well, I already have the IV on him because she knew he was going to need one when they came in. Well, I said, okay, well, what do you want me to do? So I went and got the meds out for her. I brought them to her. They were closed. But we did not know how to put them back. And I'm being dead, cause we had just changed, so that's,
Are you allowed to pull medications that you're not going to administer as a nurse?
as long as it's the correct medication, yes. I mean, but if she needed me to administer it, I mean, I would have.
So when you pulled the medication, you didn't know if you were going to be the individual to administer it.
Correct. That's why I took it to her closed and to look at the order, to review the order. She was learning to put in orders because that was like the day that they were learning to put in orders.
And did Mrs. Sanders tell you in February of 21 that you were not allowed to pull from the Omnicell or Pyxis machine?
That story is actually fabricated, and that is what I was really wanting to hit on. I had gone to Miss Sanders because we do not have a protocol at Ochsner Rush to waste Diprovan. And there is a lot of abuse of Diprovan. And I had gone and mentioned it to the charge nurse and the manager of the ER that we needed to start wasting this. They were really close. One of them went to Miss Sanders and, told her I was overstepping my boundary and all this stuff. Me and Miss Sanders, I had actually gone up there to tell her I wanted to come out of that position. And that is when she said it would be best just to not pull, and it wasn't just narcotics. It would be best just not to pull medications.
So you do admit that Ms. Sanders told you not to pull any medications? Is that
Well,
correct?
to
whether it's
avoid,
sold or not.
to avoid having conflict with this one nurse that I was having conflict with. But
Yet
that,
2 months later, you pulled Demerol for a patient that you weren't taking care of. And you overrode the machine to do it.
well, okay, I didn't override the machine intentionally. Everything was having to be overrode. But yes, I'm floating, and that is the job as the float nurse, is to assist the nurses in what they needed done.
At Queen City, you tested positive for oxycodone.
Correct.
Why is that?
I had mouth surgery, oral surgery. I have pictures on my phone I tried to bring in, but
You had mouth surgery when?
mm, October. And then like a week before I went, that's why I asked if we had thing, because I still had some of the medicine left from the initial thing. And so I told him I didn't need another strip. Like I didn't take the medicine the first time, but the second time it was a lot worse. I had braces and it had formed an abscess in my cheek.
So why did you test positive for oxycodone in December of 2023?
Still had some from the prescription, from the first prescription, and because I had another procedure where I have not formed another abscess in my cheek.
So you had I believe you testified previously you had surgery in October.
I did.
Did you have surgery again in December?
Yes, in my mouth. That's why I asked about Dr. Lala's medical records. I had
How many
braces.
surgeries did you have with your dentist in 2023?
2, and that's why my braces came off.
So are you sure those surgeries weren't in August and October? Because that's when you were prescribed oxycodone for 3 days each time by your dentist.
I'm not sure. I just know that I had like a lot going on. I've talked to you privately about that. I had a lot of medical issues going on that year. And so
Do you acknowledge that when you were at Queen City, you were very drowsy? Is that correct?
I wouldn't say, I'm not gonna say very drowsy. No, ma'am, I'm not gonna.
Do you acknowledge you were on oxycodone?
I did not take it that morning. No, ma'am, I did not. I didn't take anything but my morning medications that morning.
No further questions.
Ms. Levitt, the board may have some questions for you now.
Have you ever had a chemical dependency exam?
Yes, ma'am.
Is it in our wrestling?
It was in 2014. And then the provider keeps a check on that too.
Where that is?
Do I have the 2014 evaluation? I don't. If I had it, it'd be in here.
I personally have a lot of trauma in my life and a lot that has happened. And I know that like what that looks like, but I've had a lot in the last 10, 11 years. And I've was aware of that.
On your previous chemical dependency exam, did it say that what were the results?
That there was no sign of any chemical dependency. Christina, should I tell them what's going on? Should I tell them what's going on? So I was just asking and to fill y'all in of what's been going, what I've been through in the past. I was verbally, emotionally, physically abused in the last 7 years of my marriage. I've had 8 miscarriages that I've delivered 3 of them. So I have one daughter, and she's very special to me. I lost my dad to sudden cardiac death while I was dealing with postpartum depression after she was born, and that was in 2000. My divorce just occurred back in. Back in September.
We'll take a brief 5-minute recess.
I took some of the time off for work just to kind of take care of myself, figure out things to do because my dad was kind of my backbone to help me. He was the one I'd call, when I was working in surgery. And I didn't have that anymore. I mean,
If we decided as a panel to put your license would be maintained with certain stipulations, would you be willing to comply with whatever stipulations the board would see fit?
um, honestly, it, I don't know. I mean, more than likely, but I mean, I'm a good nurse. I'm a smart nurse. The girl that reported me that Wendell Leslie was having an affair with my husband from Oshner Rush. I'm a safe nurse. And yes, I was tired that day and I was groggy, but I wouldn't have taken care of patients if I would have caused any harm. And I didn't take care of patients. I don't deserve to be sitting here as much as half the other people involved.
Thank you, Ms. Levitt. I don't believe the board has any more questions for you. Do you have any final points you want to make before you rest your case?
Life's already hard. Just please. I'm a good nurse. I don't do wrong. I don't drink. I don't do drugs. I don't just
Right now with the closing statements, beginning with Ms. Salzman.
Mississippi Code annotated 73-15-29-1L provides that it's unprofessional conduct to practice nursing while impaired. That's what one of the charges that Mrs. Lovett has today. As recent as December of last year, she was drowsy, falling asleep while standing, or at least that's what was reported. She does acknowledge that she was drowsy. It doesn't matter whether she was impaired as a result of cocaine or whether she was impaired as a result of prescribed medications. The fact is you can't safely practice nursing if you can't stay awake. 2 years prior to that, she was pulling meds for a patient that she did not have. didn't have an order to pull that medication, and she was told 2 months before not to pull any meds from the machine based on her history. That prior history with the board is that she admitted to injecting herself with Demerol while working as a nurse. And today you heard her testimony that she's never had any type of addiction problem. She's never completed any type of treatment or counseling. And although she did successfully complete the terms of that 2013 discipline, it's important to note that just a few years later, she's still pulling Demerol via an override when not ordered to do so. The duty of this board is to protect and safeguard the public. Practicing nursing while impaired is dangerous. Again, regardless of whether that impairment is a result of authorized or unauthorized medication. It does not matter. As such, I would respectfully ask this board panel to review 7315-29-2, and I would ask it to order, at minimum, a chemical dependency evaluation and require Mrs. Lovett to submit to regular drug screening for a certain period of time. Thank you.
Right, Ms. Lovett, now you may give your closing statement.
It keeps being said that I was impaired, grogginess from being tired, from having a lot of sleepless nights is a lot different than being impaired on medication. And there was no medication in my system that I had not been taking for a couple of years. The drug screen showed it. To put a stipulation on my license from hearsay, because those nurses that wrote that report technically are not here to defend their statements, that do not even collaborate if you look back at them. And right now, with everything, I'm trying to get full custody of my daughter and everything else. I am asking y'all, and I'm telling you, I do not have a chemical dependency problem. I can guarantee you that, because if you look back at the PMP, I quit a live medication cold turkey in 2022 when I changed providers, because that one just kept giving me medication after this bad wreck I had. Every time I'd go in, I wouldn't even ask for it or anything, and it was given no matter what in case I needed breakthrough. So I went to another provider. That's when I ended up with a mental health provider. And I had no issue stopping that medication. If you look back at that medication, he did write one prescription of a low dose, of a lower amount of one just in case, because I had been on it. I had no issue with it and ended up turning in all the pills back to him to show him that I had not taken any of them. So I don't require I'm not I'm not an addict. I just have a life like everybody else does and a lot going on in it. And I just ask that y'all please.
This concludes the hearing in case number 2021-0351 and 2023-1138. The board will make a decision on this matter today and announce that decision. This time I'll entertain a motion from the board to go into closed session to determine whether grounds exist to go into executive session to deliberate on this case.
Make a motion, we go in closed determination session to determine if executive session is needed.
We have the motion. Is there a second?
Second. A second.
All in favor? Any opposition? Hear no opposition at this time. I'll entertain a motion from the board to actually go into executive session to deliberate on this case.
Make a motion, we go into executive session for deliberations on stated license number.
I'll second.
All in favor?
Aye.
Any opposition? Hear none, we are now in executive session and the board will return with, Ask the members of the board hearing panel to state your names for the record.
Nancy Johnson.
Janelle Moody
Melissa King.
Jeremy Cummins Alton.
And now I will announce the board's decision in case numbers 2021-0351 and 2023-1138. The board finds the licensee not guilty of charge one, finding insufficient evidence to support the charge. The board finds the licensee guilty of charge two, finding sufficient evidence to support a finding of guilt. The penalty imposed is a restricted license for 12 months, pending the outcome of recommendations provided by a chemical dependency, substance abuse evaluation, and a psychiatric psychological evaluation. A fine of $500 and a limit on the maximum hours worked. The details will be spelled out in the final order, but that's the oral summary. Do you have any questions?
So do I need to go on and get the chemical dependency study done?
It's up to you, you know, under statutes, you have an appeal, right? So, but if you wish not to appeal, then the evaluation is due must be completed or accomplished within that 12-month period that your license is restricted. I'm sorry, the actual completion of restriction is 180 days from the date you receive the final order. So 6 months.
When will I get that paperwork?
Within 30 days. Any additional questions?
So once I do the pending things and pay the fine, the addiction, is my license still restricted then?
Yes, because you have maximum hours, a limitation on the maximum hours.
Okay.
Any additional questions? And should the assessor recommend more months, you know, or less, then, you know, at that time, it'll be clear, but that's what's required now at this time, by this order. Concludes the hearing. Any more questions?
No, Your Honor.
Benjamin Oglesby, license number R-899-087. I am Kristen Love. I will serve as the hearing officer today. My role during the course of this proceeding will be to rule on objections to questions or evidence raised by the party, see to the orderly process of the proceedings, and to ensure that the proceedings are conducted in accordance with the applicable laws and rules. You know, the members of the board, the hearing panel, state your name.
Dr. Melissa King, nurse practitioner.
Jeremy Cummins.
Representative of the board, state your name.
Brandon Walker.
Is the licensee, Mr. Oglesby, present? And Mr. Oglesby, are you represented by counsel? At this time, I ask your counsel to state his name for the record.
Joel Gatlin with Hearn Law Firm.
Now, I want to identify the individuals in attendance that will give testimony today, so you can be sworn in by our court reporter.
Tawanda Jones.
Please raise your hand. You solemnly swear or affirm that the testimony about to give today will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Are there any preliminary matters?
Yes, Your Honor, we'd like to introduce an evidence, B1 through B22. And also we had R1 through R10 that was previously submitted by the respondent. I don't know, Mr. Gatlin may have some more on it now. Yeah, that's all.
Any objections from the parties, related to the admission of these exhibits?
No objection, Your Honor.
Okay.
No, Your Honor.
The exhibits are admitted into the record. It follows, have opening statements, hear arguments from each side, allow for question at the conclusion of the presentation of both arguments, closing statements. Walker, if you're ready to begin, you can begin now with your opening.
Thank you, Your Honor. Mr. Oglesby has been practicing outside the scope of his license as an RN by compounding and administering IV hydration without specific orders. This is not the first time Mr. Oglesby has been charged with practicing beyond the scope of his license. In March of 2021, the Alabama Board of Nursing found that Mr. Oglesby practiced outside the scope of his license as well. Mr. Oglesby attempted to start an IV on a security guard twice, and on the second attempt, he inserted into an artery instead of a vein. Mr. Oglesby is before this board panel today because he continued to practice beyond the scope of his license. Specifically, as the co-owner of IV Hydration 2U, in this business, Mr. Oglesby travels to patients' home, mixes the patient's selected combination of fluids and medications, and then administers the IV. There are no lab assessments or specific orders, and the patient lead is not medically assessed by the physician, so there's no specific orders for the treatment. Some of these mixes included Floridol and Zofran. Mississippi Code annotated 73-15-52 states that the practice of nursing shall not include acts of medical diagnosis or prescriptions of medical, therapeutic, or corrective measures, except as may be set forth by rules and regulations by the Board of Nursing. Rule 1.2F states that an RN may formulate a nursing diagnosis and not a medical diagnosis. Mr. Oglesby has endangered the public because he had nothing on hand in the event a patient had an adverse reaction to some of the medication that was administered. Pursuant to the authority found in Mississippi Code annotated 73-15-29-1, this board has its power to take disciplinary action on the license of Mr. Oglesby as it sees fit. Thank you, Your Honor.
Mr.
Gatlin. Your Honor, and members of the board, Mr. Oglesby briefly had a contractual relationship with a company known as iDrip. And that is why he formed the entity that he did. He ended that relationship after just 4 months when he learned that there were questions regarding their protocols with this board. He did that voluntarily, not as a result of any cease and desist. At all times, the proof will show today, and you have before you the exhibits, the proof is going to show that at all times he operated under the understanding that a licensed Arizona physician and the physician's standing orders were in place and appropriate. The fact that that Arizona physician entered the standing orders that he thought were appropriate while he was contracting with iDrip is made apparent from the charging document itself, which recites on the second page, first paragraph, that he did operate under standing orders from this Arizona physician. There's no evidence in this case before you of any actual physical damage or injury to anyone as a result of any of his activities. So we'll get that out of the way first. There's no allegation that Mr. Oglesby knew or had any actual knowledge that there was any issue during that 4-month period with the Arizona physician's authority to issue a standing order and protocols to him for his behavior in Mississippi. There is no evidence that he ever actually administered or even compounded Toradol or Zofran in front of you in any kind of drip, whether under a standing order or even a specific order. In one of the 7 charges that's brought today, it's alleged that he failed to protect Mississippians from an incompetent doctor. I know of no evidence before this board that this Arizona physician has been found incompetent, that he's been charged by this board or the Mississippi Board of Medical Licensure with being incompetent. And certainly there's no allegation that anything that Mr. Oglesby did at the behest of the Arizona physician standing orders actually harmed anyone. The gist of the allegations in this case seem to stem from the position that Mr. Oglesby either knew and had actual knowledge or should have known that this Arizona physician standing to issue standing orders would not be valid. As the investigator for the Mississippi Board of Medicine suggests in a very brief, short email that's before you, one of the exhibits that was included, the investigator for this board reached out to her counterpart, the investigator for the Mississippi Board of Medical Licensure, and had to ask about the rules applicable to the Arizona physician issuing standing orders to Mr. Oglesby. And she was informed that there was a rule that because of a locality rule, he was over 75 miles away, he would have had to come here and appear before the Mississippi Board of Medicine, things like that. All of those rules apply to the doctor, not to Mr. Oglesby. And they had to be learned by the investigator on behalf of this board by asking the Mississippi Board of Medical Licensure. And then they want to turn around, the charging documents want to indict the behavior of Mr. Oglesby for not somehow automatically knowing that rule that's applied to the doctor by the Mississippi Board of Medical Licensure. That seems wholly unfair. But that email is in evidence before the board. There's no protocol whatsoever for this nurse to investigate a doctor in Arizona and ensure that he has complied with the locality rule that's described in that email. Yet he's being held to full account for not automatically knowing that this Arizona physician had not complied with that rule, apparently. The allegation is made in these charges as well. And actually, there's 2 paragraphs in the charges that are said to undergird all 7 of the charges. And these are the reasons why we believe all the charges are insufficiently supported by the evidence. In those 2 paragraphs that supposedly support all 7 charges, the statement is made that no documents have ever been submitted to this board or the investigator that were signed by a physician. That's demonstrably untrue. In fact, there are no less than 18 documents, not 0, 18 documents in these exhibits signed by the Arizona physician. Therefore, this whole proceeding should be thrown out. This should be dismissed. It's not fair to my client. It's certainly without sufficient evidence to find him guilty of any of these charges. Also, there are several things that were incorrect in the investigator's notes that are Exhibit B13. We're going to show today that she cut and pasted and apparently confused her investigation with her investigation into at least one other nurse who was accused of similar patterns of practice regarding some hydration services. You can tell that she cut and pasted them in that she said that described my client as a her in multiple places in the questionnaire and recited things that were apparently cut and pasted from the answers that the her or the female nurse that she apparently had interviewed in some similar case. And she substituted that female's answers for my clients in several instances. And just one example of that, as we'll show, is that where she stated that her or the she said she had no medical equipment on hand in case any adverse reactions were experienced by any patient. My client absolutely had epinephrine on hand, and that was not his answer to the question. And you can tell that by the cut and paste where she mentions her, she repeatedly instead of him. So the investigation seems to have been a cut and paste investigation where we took some information that was given by a nurse, some other nurse that was under charges by this board, and extrapolated them over to my client. Finally, there's clearly a lot of tension here between a medical diagnosis and a nursing diagnosis. And I think we can all agree that nursing diagnoses have long been an issue of gray area where doctors and nurses try to delineate between what is a nursing diagnosis and appropriate as opposed to practicing medicine. And here's the thing. The charging document states in the paragraphs that supposedly undergird all 7 charges, that paragraph states that, quote, it is recommended that medication orders be specific to the patient to help obviate the notion that the nurse is prescribing medication. So he's being charged 7 times, 7 counts, all related to the statement that it is, quote, recommended that these things be done. It doesn't say required. It says in the charging document, it is recommended that medication orders be specific to the patient. When we're talking about standing orders and how far they can go, I know we all value our medical license or our professional licenses, my law license, your nursing licenses, we've all worked hard for them. To be indicted, sitting here, put yourself in this man's shoes for something where the charging document says it is recommended that you do this seems entirely inappropriate and insufficient. Your Honors, all the information, the 2 paragraphs that supposedly undergird the charges show that there is insufficient evidence to support the charges in this case, and this man's been punished enough. And that I will conclude my opening argument with that.
Mr. Walker, if you're ready to proceed, you can call your first witness.
Yes, Your Honor, we call it Tawanda Jones. Excuse me. Ms. Jones, state your name, county of residence, and your current place of employment for the record, please.
Tawanda Jones, county of residency is Rankin County, and I work for the Mississippi Board of Nursing.
And how long have you worked for the Board of Nursing?
I've worked for the Board of Nursing for 6 years.
And what is it that you do here at the board?
I investigate allegations regarding the nurses that are reported to the Board of Nursing.
If you would, turn to page 5 for me. And ID that document.
That's the B5 is a licensure certification.
And when does it show that Mr. Oglesby was first licensed in Mississippi?
He was first licensed on January 8th, 2015,
What was he licensed as?
a registered nurse.
Okay, does that document show that he's been licensed as anything other than an RN?
No.
Okay. If you would, please turn to page 11 and ID that document.
Page 11 is the complaint.
And can you tell us the charges that are against Mr. Oglesby today?
Charge 1 is, do you want to read on?
Yeah, you can just read it out.
Okay. Charge 1, the respondent engaged in unprofessional conduct as identified by the board and its rules, namely practicing nursing beyond the authorized scope of a license or directing others to practice beyond the authorized scope in violation of 30 Mississippi Administrative Code PT 2820 R 1.2. Charge 2, the respondent engaged in conduct likely to deceive, defraud, or harm the public. Charge 3 is the respondent has negligently or willfully practiced nursing in a manner that fails to meet general accepted standards of such nursing practice. Charge 4, the respondent was negligently or willfully acted in a manner inconsistent with the health or safety of a person under the licensed care. Charge 5, the respondent engaged in unprofessional conduct as identified by the board and its rule, namely possessing, obtaining, furnishing, and administering drugs to any person, including self except as legally described, directed in violation of 30 Mississippi Administrative Code, PT 2820R 1.2R, and charge 6, the respondent engaged in unprofessional conduct as identified by the board in its rules, namely failure to appropriately act in safeguarding the patient from incompetent healthcare practices or practitioners in violation of 30 Mississippi Administrative Code PT 2820R.2, and charge 7 is the respondent has negligently or willfully violated any order, rules, regulation of the board pertaining to the nursing practice or licensure.
Okay, thank you. And that charge 6, was it, will you read that for me one more time?
Respondent engaged in unprofessional conduct as identified by the board and its rules, namely failure to appropriately act in safeguarding the patient from incompetent healthcare practices or practitioners in violation of 30 Mississippi Administrative Code PT 2820R 1.2.
So did that limit it to the practitioners specifically? That charge, did it,
Yes,
or is there an or in there?
it is an or.
Okay, so it's not limited to just practitioners?
Right, healthcare practices or practitioners.
Okay, can you, on the next page, are there any summary, are there any facts in the complaint that support the charges?
Yes.
Can you kind of sum those up and tell us what those are?
The respondent had a previous disciplinary action in Alabama with the Alabama Board of Nursing for practicing outside of his scope as an RN. And the respondent has been practicing out of the scope of a registered nurse by administering IV hydration without specific orders. The respondent is a co-owner of IV Hydration to You, and IVs are administered based on what the clients want. And there's no medical justification for the selected IV.
Okay. At the time, you performed this investigation, correct? For this case?
Correct.
At the time this complaint was issued, had you received any medical records that were signed by, or any medical records at all?
No, they were requested on multiple times, but I did not receive them until later.
Okay, if you would go to page 16. Can you tell the board panel what this is?
This is a list of the IVs and things that the respondent offered through his mobile hydration business.
So what do these pictures show, or what is it labeled as?
It says a full menu of easy access, and it's IV menu, the different blends and therapies that are offered by way of a menu.
So this is what, a menu that they could pick from?
Correct.
Okay. If you look on page 17, can you tell, for the record, identify what that document is?
Page 17 is a social post based on the respondent where he is advertising a mobile IV spa, which offers a variety of items for groups, wedding parties, and it operates in Mississippi and Tennessee.
Okay, and who made this post? I'm sorry.
The respondent
Okay.
made this post.
And it talks about a menu, is that what you said?
Yes.
Okay. All right, on page 18, the next page. What is this exhibit?
Page 18B7 is IV Hydration to You. It is a list of injections that the clients can select from.
So is that different than the other ones?
These are all injections, the other
Okay.
are IVs.
And on the next page, what are those?
The next page, B8, is an IV menu of various IV therapies that clients can select.
So essentially the same thing as page 18. This is just an IV menu?
Yes.
Okay. All right, well, let's go over to page 37. Can you identify this for the record?
These are questions that I asked to Mr. Overman.
Okay, can you kind of talk to us about this document and tell us what it is? Or what you asked?
These are questions asked, the first question, was he a nurse or a nurse practitioner? And his answer was no. Do you have orders for the provider? And who examines the patient? And he says, yes, he has standing orders. The provider is provided by the agency.
So these are questions you asked him during an interview?
Yes.
Is that correct?
That's correct.
Does he talk about the patients, does he ever confirm that patients can actually select items or, I'm sorry, injections or IVs from a menu?
Yes.
And who was the doctor? Is it mentioned in there who the doctor was that prescribed, that had the standing order?
Dr. Feisenmeyer. Yeah, I will. FEINZIMER.
And where was he located at?
In Arizona.
Okay, does he also note about any labs being done regarding these IVs or injections?
I specifically asked the question and he said no lab work is done prior to the IV hydration.
And what did he answer whenever you asked him if he had anything on hand for any type of emergency?
But his response were, if something were to happen, he would call 911 and a medical director to inform them of the emergencies available, that if any occurred. He had no crash cart available.
So who actually assessed the patient?
The respondent.
And did he say that he mixed the bags when he was there?
He
For
does.
his-
It's
okay.
a mobile business, so when he gets to the location, whatever they have selected off of the menu, he will put those components in the bag of IV.
Okay, let's turn over to page 40. Can you tell us what this is, please?
This is a United States Code annotated.
Okay, and what title is this for?
Pharmacy compound.
Okay. And when you read the section, you see the section is subsection A there, or little section A. And it says, or we read for it all the way down to where it says 1B,
1B.
from A all the way down to 1B.
Okay, this is section 351A, 2B, 257FL, and 355 of this title shall not apply to drug products if the drug product is compounded for a identified individual patient based on the receipt of a valid prescription order or a notation approved by the prescribing practitioner on the prescription order that a compound product is necessary for the identified patient. If the drug product meets the requirements of this section, and if the compounding one is by a licensed pharmacist in the state, licensed pharmacy, or a federal facility. B is a licensed physician.
No, that's fine right there. Thank you. So in that statute, who are the two people that it names that can compound?
The two people named in this statute are a licensed pharmacist or a licensed physician.
If you will turn over to page 43, I believe it is. Yeah, 43. You see E right there?
I do.
Will you read that for us as well?
Compounding defined. As used in this section, the term compounding does not include mixing, reconstitution, or other such acts that are performed in accordance with directions contained in approved labeling provided by the product's manufacturer or the manufacturer directions consistent with the label.
So according to this, it's saying if you mix it according to the label, that's not compounding.
Correct.
Okay. Was Mr. Oglesby, you said this earlier, but was he a pharmacist or a licensed physician?
No.
All right, let's turn over to page 58. And I think it's B22 is what it's labeled as. Can you tell us what this is?
This is a dosing for blending of the various IVs that were listed on his menu.
All right, and so according to that interview, this is what he said he was mixing and administering. This was part of his therapy. Is that correct?
This was listed on his social media as menu items.
Okay. Let's go back to page 22. Can you tell us what this is, Ms. Jones?
Page 22.
Yes, ma'am.
Page 22 is IV hydration to you. And it's the add-ons for the IV.
So these are add-ons that you could, meaning you could select them to add into the IV.
Right, these are options that the clients had to choose from.
So these, if you mix these in, they would be compounding essentially by what we just looked at.
Right.
On page 39, will you identify that for the record as well? Excuse me.
Page 39 is an email from Jonathan Dalton to Tawanda Jones.
And can you, what does he say regarding the standing orders, from a medical standpoint?
This is where he's saying that Dr. Feinsmeyer would need to personally evaluate a patient's administering IV fluid. Standing orders are not valid. In my experience and opinion for patients, a provider never sees.
And what does he say about the doctor specifically?
The doctor is beyond the 75-mile radius. And if a doctor is beyond a 75-mile radius, then they must come before the board with protocol, asking permission.
So even if these standing orders that he was operating on were valid, if we were saying those were valid, they weren't even compliant with medical boards, right?
That's
They would still
correct.
be out, okay. All right, turn to page 60 for me, please, ma'am. Will you tell us what this is labeled as?
This is an intake form.
Okay, what does the patient say, or what date does the patient say on this intake form? I'm sorry, Your Honor, I forgot, and I apologize. Can we, I would request to seal the records because it does have patient information in here.
Any response, Mr. Taylor?
We'll agree to that.
I apologize, Your Honor.
Made it under seal. Patient information.
So, sorry, Ms. Jones. What date does the patient say she would like to be seen on number 2?
The patient dated March 4th, 2023 as the date to come by.
And at the bottom of the page, what day does she say, or was this intake form completed?
The footnote on the page says completed by the client on February 9th, 2023 at 8:00 p.m.
And on the next page, on page 61, who's the last signature on that page?
Dr. Feisenmeyer.
And so is that the same doctor we just discussed a minute ago?
It is.
What date does it show that it was signed by him?
The physician signed this statement on March 27th, 2023 at 12:24 p.m.
And you said this earlier too, but these were records you didn't originally have, correct?
That is correct. They were requested multiple times and we did not get the records until late.
So by that date, you just said it was March 27th, is that what you said? I'm
That's,
sorry.
that's the date that the physician signed the record.
Okay, so was this after the patient was seen? From the record? Or from what the intake form shows at least?
It was after the dates listed on the intake form.
Okay, let's turn over to page 114. So have you got it?
I did.
Okay, is this the same form, similar form we just looked at?
It is an intake form.
Okay, and on this patient, you don't have to say a name. When was a visit requested then?
On today,
And when does it show that it was completed? At the bottom, I'm
the
sorry.
footnote indicates that it was completed by the client on November 1st, 2022 at 3:15 PM.
And when does it show that it was signed by the physician?
The physician did not sign this document until March 27th, 2023 at 12:22 PM.
So it doesn't appear that the physician saw the patient at all before a visit. Is that correct?
That's correct.
Okay. And have you looked at all these records? Ms.
I
Jones?
have.
Is the signature date for the physician the same?
It is. The signature date for the physician are all dated March 27th, 2023.
So, and it's all after the patients have been seen, is that correct?
That's correct. It is after the fact.
So there's no assessment being done by a physician for any of these patient records that we've seen.
No.
Okay, will you go to page 36 for us, please, ma'am? Can you tell us what this document is?
This is information from the Mississippi Board of Nursing website under frequently asked questions and answers, and is regarding medical orders.
So this came from the Board of Nursing website? Is that what
That's
you said?
correct.
Okay. And are these just based on evidence research? Are you familiar with that at all, or do you know?
It's based on evidence research.
Can you tell us what it says regarding a medical judgment?
The medical provider makes the medical judgment as a as a specific medication and dosage.
Okay, and what does it say about standing orders?
Standing orders are certainly not to be used in lieu of medical consultation or intervention.
If you go over, and these can all be accessed, you said, on the Board of Nursing website, is that correct?
That's correct.
By pretty much anybody that wants to look?
Yes.
On page 24, I'm sorry. Can you tell us what this document is?
Exhibit B10, page 24 is the Board of Oregon, Oregon Board of Nursing.
So what order was issued, what was it issued for to Mr. Oglesby?
This is for the final order of suspension by default for failure to cooperate.
Okay, let's go over to, so is this, I'm sorry. Go to page 28 for me. And who issued this order?
Alabama Board of Nursing,
And who is it issued against?
the respondent.
If you would you read numbers 3 and 4 on page 30 for us? I'm sorry, 30 and 31.
3 and 4.
Yes, ma'am.
Okay, 3. On or about June 2019, while employed as an RN at UAB, respondent used a local security guard, non-patient, as a volunteer to educate a student assigned to him on the use of a transducer. Respondent attempted to start an IV on the security guard twice. On the second attempt, an IV was inserted into an artery instead of in a vein. The respondent noted, confirmed of the mistake by ultrasound and stated he noted his charge nurse of the occurrence. He further asserted the guard denied having problems and circulation was maintained. On or about July 1st, 2019, the guard informed the facility's human resource officer of the occurrence, and he reported that the process was very painful during a few days after the procedure. And you said 4?
Yes, ma'am, 4-2.
4 is the respondent testified that his location at UAB had a long practice of using employees to safely demonstrate procedures to student nurse. And he was seeking to demonstrate the transfusion setup and show vein pressure. He stated that when he discovered that he hit an artery, he immediately advised his colleagues. He asserts that the incident resulted in termination only because he was within his 6-month probationary period. He testified that the security guard volunteered for the procedure, and the guard indicated that he had volunteered for similar tasks in the past.
So while trying to start an IV, he hit an artery. Is that what the findings of this board order were?
Yes.
And if you would go down to page 6 on, I'm sorry, number 6 on page 32. The next page. And would you read that for us as well?
The respondent's conduct as described in paragraph 3 above demonstrated that he practiced beyond the scope of an individual licensed nurse practice as determined by educational preparation in violation of Code Alabama 342125B1G and Alabama Board of Nursing Administrative Code 610X8 037B1. Said conduct is unprofessional conduct as a character likely to deceive, defraud, or injure the public in a manner pertaining to health. Excuse me.
So he's already received discipline for essentially practicing outside of his scope, correct?
Correct.
And this particularly, as we just said, was for him trying to give an IV. Is that what-
That's correct.
And so what was his business that he was operating? They just said that he's no longer doing that anymore, but what was his business that he was doing before?
He was a nurse at the UAB hospital.
What was his operation that he was doing in the IV to you? What did that entail him doing?
I don't understand.
Whenever these records we've looked at for his operation, his business.
IV hydration.
Okay, so he was operating and giving IVs out of a mobile clinic is what your investigation?
That is correct.
I have no further questions, John.
The cross-examination, Mr. Gatlin.
Ms. Jones, what did your investigation consist of? Other than the interview with my client and the email to the investigator at the Mississippi Board of Medical Licensure? Did you speak to anyone else?
Just to your client, and I did request records on numerous times, his medical records.
Okay. Did you interview any of the patients or any of the people that he encountered when he was with IDRIP for those 4 months?
Yeah.
Is there a reason why you did not do that?
No, I don't deal with the patients. I deal with the nurse.
Is there any allegation that any of the people that he encountered during those 4 months were actually physically harmed?
I don't have that information now.
Okay, so there's no evidence before the board of that?
No.
And no accusation of that, right?
No.
All right. Can I turn your attention to the formal complaint that the Board of Nursing brought against my client that has us here today? I think that's pages 11 and 12. I direct you to please look at the second paragraph, the first full paragraph on page 12. You see we're halfway down the paragraph. There's a sentence there that says, "It is recommended that medication orders be patient/condition specific." Do you see that sentence?
Said halfway in paragraph 1, halfway.
Down the first full paragraph that begins with respondent. Halfway down that paragraph, to the right side, there's a sentence that begins, "It is recommended that." Do you see that?
Oh, it is recommended that medication orders be patient/condition specific to take away the notion of the nurse prescribing medication.
Okay, so we're talking about recommendations and notions here, right? In that sentence.
That's what it says, recommendation.
Do you agree with that statement?
In my personal opinion,
Yeah, I gotta object. She doesn't have she's an investigator, not a medical. She can't give a medical diagnosis or a medical opinion on a medical statement.
Okay, and let me back up and ask this. I'm sure you've testified at many of these hearings, right, over the years? Okay. Have you testified at several or many appeals to the Chancery Court in these kind of proceedings?
have I specifically
Yes.
testified? No,
No. Have you testified in any of the Chancery Court proceedings?
no.
So finally, going back to that statement that you just read regarding the recommendation and the notion that distinguishes practicing medicine versus nursing assessments. Would you agree from reading that there's no black and white rule, just a recommendation on that subject?
I don't know that. I can't answer.
Okay, but that's what it says here, isn't it?
It says it is recommended that medications orders be patient/condition specific to take away a notion of the nurse prescribed.
Thank you, Ms. Jones. Do you have any evidence that my client actually compounded Zofran or Toradol in a drip and administered it to anyone?
I don't have evidence, no. I just have his medical records.
Okay,
now.
all right. Do the medical records demonstrate that he actually compounded any of those drugs and administered them to anyone?
I would have to go through each individual one to answer that.
Are those, and I would ask you, I know you're the sole investigator in this case, right?
Correct.
Okay, so if anybody's going to know that, it would be you, right?
Correct.
Okay, and you don't know that?
No.
Beyond a menu that suggested that he might administer or compound those, is there any evidence that he ever actually did do that?
I would. Based on these 10 records that he provided to us, there's not a check for those.
Okay. All right, Ms. Jones, you reached out to your counterpart, the investigator for the Mississippi Board of Medical Licensure at one point, right?
Correct.
Okay, and if you would turn to, let's see, that's exhibit B14, page 39. Who is that email from?
This email is from Jonathan Dalton, the chief investigator for the Board of Medical Licensure.
Okay, and what caused you to reach out to Mr. Dalton?
What caused me to reach out to Mr. Dalton was the fact that Mr. Ogilvy informed me that he was not a nurse practitioner. So I wanted to find out about the orders for those patients for the IV hydration and any other add-ons that he had. So he told me that his medical provider was Dr. Feisenmeyer. So I wanted to make sure that that physician was actually licensed in the state of Mississippi, given that he lives out of the state.
All right, and what did you determine from this email?
I determined that based on the medical licensure rules and regulations, that this physician lives outside of a 75-mile radius. And that if he was the medical provider for this particular business, then he would have to come before the board with protocol to get permission to act as a medical director.
Okay, and you did not know about this 75-mile locality rule before you received this email?
No, I knew about that.
Okay. Tell me, is there any protocol for a nurse in Mississippi to do this kind of investigation on a doctor who provides him with standing orders?
Is it a protocol for a nurse to?
A protocol or a requirement that's in black and white, to your knowledge, to require a nurse to reach out and investigate an Arizona physician's ability to write standing orders in Mississippi?
It is a requirement if you are a nurse practitioner, but not for an RN.
And to what extent would a nurse practitioner be required to verify the licensing and ability of an Arizona physician to write standing orders in Mississippi?
Given that I don't work as an investigator on the nurse practitioner side, I can't answer that.
All right, looking at your questions that you asked Mr. Oglesby and that you documented in Exhibit B13, I see that B13 is only about a page and a half long. Was this the totality of the questions you asked him in the interview?
Yes,
So you documented everything you asked in that interview?
I did.
Okay, how long did that interview last?
I interviewed him more than once. The first interview didn't last very long because that attorney told him not to talk.
Okay.
The second interview was here at the Board of Nursing, and it lasted he was on Zoom, and it lasted maybe 15, 20 minutes, went over the same questions.
Okay, is that Zoom recorded?
I don't know.
Okay, did you record an audio recording of this interview by chance?
I can't audio record any interviews.
Okay, so the only documentation of the interview and the answers are what we have here in Exhibit B13,
That's
what you remembered and recited.
correct.
Okay. And you said the interview lasted 15 or 20 minutes?
I'm estimating because I did not have a clock on.
I mean, if you look at these questions, it does not look like this would have taken 20 minutes to go through. You really believe it took that long? And you're sure everything's here?
Again, it's an estimate.
Okay. When you ask this gentleman where the medical records are housed related to people that he encountered while he had a contract for 4 months with iDrip, I see that you notated that he answered at my house, right? Okay. Was that also an answer given by another nurse, possibly a female nurse that you investigated from North Mississippi?
It absolutely was. Her records were at her house as well.
Okay. You don't recall my client telling you that he kept the records, sent them to iDrip on secure HIPAA compliant servers?
I remember that on the second interview.
That was on a second interview? Why is that not documented here?
Well, these are questions from the first interview.
Okay. So you did not submit questions from his second interview in evidence today,
They pretty much were the same questions. He just added something different to it.
except that it was a very different answer, wasn't it, to that question about where the medical records were housed?
Yes.
So they were not housed, he did not answer that they were housed at his house, but on a HIPAA compliant server with the company he had contracted with.
No, the first time he answered, they were housed at his home.
Okay, let me ask you this. Do you think it's possible that you confuse some of the responses from the North Mississippi female nurse that you questioned in a similar case with some of the responses of my client?
No,
Okay, then I'm going to ask you, why did you refer to him as a her repeatedly in this document?
just an error in typing.
Okay, were you cut and pasting from her interview answers?
No, as a matter of fact, I had a whole separate, this list was, I had a list for each nurse. And the questions were the same.
How many nurses were there that you investigated? Two. Okay. And that brings me back to this hydration service, iDrip. Did you do any investigation into iDrip and their procedures?
No, I looked at the nurse.
Okay. Are you aware that there are as many as 6 different territories that iDrip had attempted to set up in Mississippi?
I've heard of that, but I don't know that specific.
Okay. To your knowledge, has this board brought any charges against all 6 nurses that contracted with iDrip or just my client and one other?
I wouldn't be able to answer that legally.
Okay. So you're not aware if any charges have been brought against other nurses related to iDrip services?
I only,
Objection, Your Honor. We're not here about other nurses. We're particularly on Mr. Oglesby.
All right, Mr. Gatlin, any response?
Well, I think it's relevant constitutionally, whether my client's being treated with due process and fairly, or whether he's being singled out for selective prosecution. If there are 6 other nurses around the state who did similar things and they haven't been charged, and that's what I was trying to get to, so that this body can determine the truth of whether this seems to be a fairly selective and ambiguous prosecution of these charges against my client.
don't know that we heard any evidence today that, about 6 other nurses being charged. So, I'm gonna, overrule your objection.
Thank you, Your Honor.
I'm sorry. Just saying.
Bear with me 1 minute, Your Honor. Ms. Jones, do you know what complaint or who the complainant was that was the genesis of these charges in your investigation?
Of this specific charge,
Or the genesis of your investigation into Mr. Oglesby?
this has been a while. I do not know right offhand. No, I don't.
Is that something you can disclose if you knew or no?
No, I wouldn't.
Okay, so do you recall if the genesis of this investigation was a complaint into iDrip's business model as opposed to Mr. Oglesby individual?
No, I strictly deal with the investigation of the nurse.
All right. And again, to your knowledge, was anyone physically harmed by my client's activities during that 4-month period?
I don't have any knowledge of that.
Is there anything that would have prevented my client in his role that he was playing after he contracted with iDrip? Was there anything that you know of that would have prevented him from reaching out to the doctor in Arizona and asking for specific orders in relation to individual patients if he had ever been asked to give Toradol or Zofran?
I can't answer that because I don't know what he was thinking. I don't know.
My question is there anything that, to your knowledge, in terms of the Mississippi Board of Nursing's rules, that would have prevented Mr. Oglesby from reaching out to the Arizona physician and receiving specific instruction rather than standing orders to provide Zofran, for instance, to a patient? Is there anything that you know of that would have prevented him from reaching out to that Arizona physician to ask for that specific authority?
I don't know of any. No,
Okay. And so he could have done that, couldn't he, if he wished to?
if he wishes to.
Okay. And we don't know that he did not do that, do we?
I don't know that. It's not documented.
And there is, in fact, no documentation that he ever gave anyone any of those drugs under a standing order, is there?
I can only speak for the 10 files that he selected to send to the Board of Nursing.
You could have subpoenaed all the files, correct?
I could have, yes.
Ms. Jones, did your investigation show that Mr. Oglesby actually knew that this Arizona physician was violating any physician rule, like the locality rule? We talked 75-mile rule. Did your investigation show that my client ever had any actual knowledge at all that this Arizona physician was violating those medical board rules?
I don't know if he knew that or not. I don't know that.
So you can't say that he had actual knowledge that this Arizona physician was not complying with some locality rule in Mississippi.
No, I can't answer that.
Thank you. All right. Are you still yet trying to hold Mr. Oglesby responsible in these charges for not knowing that?
Yeah, I object to that too. She can't answer a legal question on what he's being held to. She just investigated the case. She didn't charge the respondent.
There's nobody else. She's the sole witness. Who am I going to cross-examine about what we're charging him with and what we're not, what we're holding him accountable for in these allegations? Because it certainly appears that that is the very allegation that undergirds all 7 charges, is that he knew or should have known that this Arizona physician wasn't complying with his medical licensure requirements to come all the way from Arizona and do things in Mississippi. It's the whole reason we're here.
No, Your Honor, it's not. We're here because he was practicing outside of scope. If you read the charge, it actually says incompetent healthcare practices, not just practitioners. There's an or. The charge of the complaint is he was practicing outside of scope.
And Your Honor, it's circular, because then we get back to the gray area of the charging document saying he's practicing outside of the scope because it's recommended that he do certain things so it doesn't suggest that he's practicing medicine and going beyond the scope of his license. It's all the same thing. We keep going back to the same undergirding document that says it's recommended, so that the notion that he's not going beyond his license isn't apparent to the public and harming the public. Well, I mean, we're talking about notions and recommendations, not hard black and white rules. And I think that's obvious from the responses from the sole investigator we have to cross-examine here.
Mr. Gatlin, are you asking her to, make a legal determination?
I'm asking her if he's being charged with the underlying, because of the underlying fact that he supposedly either knew or should have known that this Arizona doctor wasn't fully compliant with some Mississippi 75-mile rule. And if she doesn't know, that's fine. I mean, I'm certainly accept, I don't know, but that's what the documents seem to suggest.
The objection is, overruled to the extent that you're not asking her to, make a legal determination.
Right.
Or a legal decision on, the charges, the pending charges.
I couldn't hear you, Your Honor. I'm sorry.
To the extent that he's not asking her to like make a legal determination, she can testify to her knowledge on it.
So Ms. Jones, are you finding fault with my client as an undergirding fact, all these charges, with the fact that he actually supposedly knew that this Arizona physician wasn't complying with his duties to Mississippi?
Repeat your question.
Well, not the legal conclusion, the fact of the matter, of whether my client knew or should have known that this Arizona doctor wasn't complying with his duties to Mississippi. Are you aware of anything that suggests that my client actually knew or should have known that this Arizona doctor wasn't doing his duty to Mississippi's board?
I don't know.
Fair enough. Ms. Jones, I know we've talked a little bit about the gray area between a medical diagnosis and a nursing diagnosis that is permissible versus medical diagnoses and medical practice that's not permissible, right?
Right.
Is it ever permissible for a nurse to make a nursing diagnosis under standing orders?
Your Honor, that's, again, he's asking for a medical. She's not a medical expert. She just investigated the case. She can't say what's appropriate for a nurse to do.
Any response?
Again, Your Honor, I mean, these charges, her testimony, the documents she's provided are basically she's the only witness that we can cross-examine as to whether or not what the charges are and what the basis is. So that's what I'm trying to do.
The objection is sustained because I do believe that you can ask the questions and regarding her investigation that led to these charges without asking her to make any legal.
Bear with me one moment, Your Honor. Okay, Ms. Jones, if you would, please look at exhibit, well, it's page 11. I'm not sure which exhibit number this is. It's the charging document, the complaint. Page 11. Will you please look down at charge 7, the final charge, and read that one for us?
The respondent has negligently or willingly violated any order, rule, or regulation of the board pertaining to nursing, practice, or licensure.
What information do you have in your investigation that he did anything to violate this broad charge that's not already enumerated in the 6 charges above it? Is there anything else that's not in those 6 above that that fall into this broad category? In other words, of he's negligently or willfully violated any order or rule of the board? It's so broad. I want to see if you could give me an idea of what that encompasses that's not already in the first 6 charges.
What I can tell you is that he's an RN, not a nurse practitioner, and he was working on standing orders, not patient-specific orders.
Okay, can you tell me what conduct in charge 2 respondent was engaging in that was likely to deceive, defraud, or harm the public?
The conduct that I know that he exhibited was the fact that patients filled out a intake form for services off of a menu for IV hydration and IM injections. And he did not have a medical provider to assess that patient.
All right, so in your estimation, the standing orders, if he believed them to be fair and accurate and followed them, it does not obviate that.
Repeat that?
So in your estimation, if he acted on standing orders that he understood to be for an Arizona physician that could do that in Mississippi, how could he mislead the public if he believed that? If he believed he was operating on valid standing orders from an Arizona physician?
I can't answer that.
Ms. Jones, in your questioning, and by Zoom, I think you said it was, of my client.
The second interview was by Zoom.
Okay. Do you recall discussing crash carts and emergency situations with him?
I specifically asked him if he had a crash cart, and his answer was no.
Okay. Did you talk to him about his medical procedures that he would follow if, and the protocol under his understanding of the standing orders, if there were an emergency?
If it were, and I think it's listed in that statement, if there was an emergency to come up, he would call 911 and inform the medical director.
Okay. And calling 911 if there was an emergency, certainly it doesn't violate any nursing board rule, right?
No.
Okay. And him having epinephrine to administer if there were a reaction, that's consistent with being able to provide medical care if there's an emergency, correct?
But I'm not a medical professional, so I don't.
Okay. Bear with me 1 second, Your Honor. I think I may be finished with this witness. Ms. Jones, let me ask you about your understanding of the compounding rule. On page 43, Mississippi Board of Nursing, page 43, compounding defined. Did you see that? Can you read that for us?
As used in this section, the term compounding does not include mixing, reconstitution, or other such acts that are performed in accordance with directions contained in approved labeling provided by the product's manufacturer or other manufacturer directions consistent with the labeling.
All right, there's one of the charges, at least one of the charges in herein deal with compounding. Do you have any evidence before the board, in any of these exhibits that my client was compounding in any manner other than what is recited in this rule?
What I can tell you is that Mr. Ogilvy told me that this intake form is what the clients determine what they want in their IV hydration.
All right, and do you see in this rule where it discusses anything regarding a client's request or a patient request as opposed to simply a definition of what compounding is and is not?
No, those words are not used.
Okay, so we're talking about compounding with this definition, right?
Yes, it says compounding
Okay.
definition.
And do you have any evidence that you can point to in any of this packet of exhibits for the board that suggests that he was doing anything wrong in compounding that's not defined here as permissible? Let me rephrase it. I'll withdraw it. What did my client do specifically in terms of compounding or combining anything in an IV that you can point to, that you have proof of that violates the compounding rule?
What I can tell you is that when I interviewed him, he told me, once the form is completed and the client puts down what they want in their IV, he goes to their home and he will determine what needs to be in that IV. Whatever it is that was on that menu that they want, he would go to their homes and add that to that IV for that patient.
All right. And did you examine the protocols that he believed he was under from the Arizona physician for doing that?
He provided me with some standing orders.
Okay. And under those standing orders, do you have any evidence that he ever did anything to violate the compounding rule as it's stated here?
I don't know.
I have no further questions for this witness. Your
Just a few, Your Honor. Are there any records any medical records that showed any vitals or any type of assessment that was done or any lab values that were taken?
No, there in all the 10 records that he provided to the Mississippi Board of Nursing, there are no lab values in those records.
Did he indicate that well, let me back up. Did you subpoena for the medical records? Did you issue a subpoena for the medical records?
We requested those medical
Right.
records.
And you only got the 10 that were supplied?
Yes, Mr. Ogilvy supplied us with 10 records.
And in any of your interview or in any interaction you've had with him or the medical records, did Mr. Oglesby indicate that he would refuse to give somebody a selection they made if it included Toradol or Zofran or anything at all? Did he say it was dependent on anything or that he would administer?
No, he did not express to me that he would refuse anything unless, well, he did say if there was something in the intake that was, that he was unsure of, then he would ask about adding something like that to the to the IV drip.
Okay, so thank you. That's all the questions I have.
Okay, one follow-up question, Your Honor, based on this, his redirect.
Let's have questions from the board now. Any questions for the board for this witness?
I have one. Ms. Jones, on page 72, exhibit R3. I'm looking through all of I think you said 10 different patient records that he provided to you.
That's correct.
On page 72, R3, I'm seeing an intake that he's got here. And I'm seeing over on page 76 that there was a administration of I guess a compound of Toradol in with one of his, is that correct?
On page 76. I do see that. Pain relief.
Right,
That's-
Toradol.
I do.
And my other question is, of all the intakes that were provided, Have you reviewed each one of those intakes?
I have not reviewed them in depth because it was after I had completed my
Can
investigation.
you look through R4 and see if you find where a physician signed off on this particular? As I'm going through these, I'm seeing physicians signing off on all of them. I can't find a physician's signature on this one that we have where Toradol was administered. Maybe I'm missing.
And that was a file that you asked me to direct my attention to.
It's R4. I think it's probably page 73 through 70. Page 73 through 80. Sure, if this is several different ones or all the same one, but I do see where
That is correct.
Toradol requested. I see where the patient signed off. I don't see where physician signed off on it either.
It is not.
Any additional questions?
I just have one question. Ms. Jones, I just want to make sure that I understood your testimony on the questionnaire that you gave on the documentation for the respondent in his house versus electronically. Could you remind me what you said about that, how the
Okay, initially, when I spoke with him initially, and I asked him where those medical records housed, he indicated that they were at his home because when we met that day, I asked him to bring a sample of his patient's records to the interview with me. He did not do that, and he said that they were housed at his home. So a couple of weeks, months later, we interviewed him again, and that's when he indicated that these records were available and it was by some way of having them on a device that was HIPAA approved.
So is this the only portions of those documentations that you were able to review?
This
So
is all that
nothing
he provided.
post visit or post injection or post IV transfusion, there's nothing to suggest that there was any kind of evaluation?
No, this is all that he
It's just
provided.
the intake.
It's just the intake.
And it's your testimony that he told you that the intake was initially, whatever was listed on the intake is what he provided.
That's correct.
All right, I would call Mr. Ben Oglesby.
Did you have any more questions for Ms. Jones?
Question number. No questions, Your Honor.
Follow-up questions, Ms. Jones?
No follow-up questions, Your Honor, but we would like to call an additional witness, but can we have a short recess, please, Your Honor? Maybe 5 minutes.
Sure, we'll take a brief recess. Noon. recess, Mr. Walker announced that he was going to call a second witness.
I'm not, Your Honor. I apologize. We're not. But we risked.
Mr. Gatling?
I'll call Mr. Ben Oglesby. Mr. Oglesby, can you state your full name for our record?
Benjamin Oglesby.
Where did you go to nursing school?
East Mississippi Community College, followed by Jacksonville State in Alabama,
Okay. What year did you get your nursing degree?
2014.
Need you to speak into the mic. They can hear you.
How long were you under contract with IVF?
About 4 months.
Did you create an entity of your own so that you could form that contract?
I did.
What was that called?
IV hydration to you.
When did you cease to do business with IVF?
Upon hearing from the Board of Nursing that there's potential complications with their business model.
And have you used the entity that you created since then to provide any similar services?
No, I shut the brand down.
Do you engage in compounding?
No.
Can you explain how that is?
So I follow the steps that were set up by the physician and the pharmacist and follow rules of mixing only in medications that come from a vial into a bag. That's the extent of my mixing. And I follow the instructions set forth in the SOPs.
And those SOPs, in your understanding, who were those issued from?
They were issued from IDRIP with 2 medical directors, a pharmacist, and in coordination with the compliance team.
And one of those Arizona doctors was the Dr. Ben F, and I can't spell the last.
Feinzheimer, I believe they say it.
Do you remember the name of the other medical director?
I do not. I would have to look it up.
But did you operate at all times under the assumption that you were operating under standing orders given by a licensed physician?
Yes.
Did you ever perform any independent investigation into this license?
No.
Are you aware of any requirements that you do so?
No.
Did you ever give anyone Zofran while under contract with Hydro?
No.
Did you ever give anyone
Toradol.
Toradol? Did you ever give anyone Toradol while you were under contract with Hydro?
No.
Were you requested to by any of the people you encountered?
Yes. One.
One, okay. And when they request a drug like that, as reflected in the record we discussed earlier with the board, is that in an intake procedure?
Yes.
Okay. And what happens then?
So the patients fill out an intake form that gets forwarded to their electronic record, which is then accessible by the physician. It is then released to me to perform the service. I believe when we are looking for, I know the one that they were referencing for page 76 did not have a signature on there. These records were incomplete, and as I had forwarded over the email, I had lost access to intake queue when I removed myself from the company. The intake queue is the electronic record that we were using for iDrip. So I was not able to get complete records. I had access to what I could, and then my access was revoked.
What was your practice in regard to a patient like that requesting Zofran or Toradol?
So it would go in on the intake form and the physician would review it and then give me access to be able to give those medications.
So the physician would have to order it from a pharmacist.
Yes.
And so your practice was to request specific instructions as to that specific patient or the Toradol or the Zofran.
Correct.
In that particular instance of that patient that you're looking at, do you know how that ended? Was she prescribed Toradol or Zofran?
She was not. She was just, we continued with the Myers cocktail.
And how can you determine that?
So based on, so we went from the intake form to the, I believe it was the SOP.
And I've heard you mention soaps. What is that? What is a soap?
So this is the nursing assessment along with vital signs and the administration record for any sort of medications that you give the patient. According to this, the patient received the Myers cocktail And she did not receive the Toradol.
Is that because you never received a specific instruction ahead of time that she could be prescribed the medication she requested?
It is, and based on a quick glance at the intake form, I would believe that it would have been exclusionary because of her polycystic kidneys.
So but just to be clear, you don't have any recollection of ever providing Toradol or Zofran to any patient while you were with Hydra?
Correct.
And you didn't tell the investigator that you did either, did you?
No.
There was some discussion a moment ago with the investigator, Ms. Jones, regarding the fact that you only produced 10 copies of medical record for these patients to the board. Can you tell me what it was that Ms. Jones requested of you in terms of medical records?
She had requested initially with the first lawyer I had contact with, she had requested a sample of them, and I was explicitly told not to until we verified the ruling that the Board of Nursing was HIPAA exempt. At that time, I had moved over to the Hearn Law Office, and I had turned those records over to the law office, who then forwarded it over. She had asked for a sample of them, and I gave her access to whatever I had.
She didn't ask for all the records?
No.
She asked for a representative sample?
Yes.
Okay. She definitely asked for less than all.
Correct.
Let's talk just a moment. We'll go back to some of the charges, but let's talk about some of the things that have been brought up here about the Alabama issue with the board there, and tell me about that.
Yeah, so that was towards the beginning of my career, where at that particular location, like many others, individuals would practice procedures on one another, so as starting IVs. And it had never come up. It was never an issue. Charge nurses were involved. Assistant managers were involved. It was a part of the day-to-day operation. And people would volunteer for it, et cetera. The issue surrounding that is that there was the accident that actually hit an artery. There were no complications. I guess the bruising was painful, according to the record. But immediately when anything happened, as documented, I escalated it to the charge nurse that was there. We made sure that he was fine. And it happened to be the other people that were involved starting IVs that night as well had been there longer than me. So they actually just got a write-up. And being that I got a write-up within my 6-month period, that's how I got pushed out to the board. Which that's not saying that there's an excuse for it. I understand we don't need to do that now. We're no longer practicing on each other. And ever since then, I have made sure to question whether it be the board or anyone else to make sure that we are not practicing outside our scope. I have taken positions as program managers and educators and everything else to make sure that we're not doing that. And Oregon was specifically related to Alabama. And that has actually been taken care of. I have been issued a letter of concern. They retracted that. I actually, the reason I did not initially respond, because I wasn't aware of it, I had went through a divorce and was not receiving my mailings. So as soon as I found out about it, by running through NurseSys, I contacted the investigator in Oregon. We worked promptly to work together. At the next hearing, they retracted it, issued a letter of concern. And it was strictly related to Alabama. That's it.
In terms of some of the questions that Ms. Jones asked you that are reflected in this page and a half exhibit B13, did she ask you specifically about the medical records and where they were housed?
That was in regards to where they work. She thought she would receive them at the meeting. They were on my computer at my home. I only have access to the HIPAA compliant records on my computer that I would have to access from there.
Were they held on a database?
Yes, they were held on a database that was operated by or purchased through iDrip.
And That's what you told.
Yes.
Did you tell Ms. Jones simply that all administration of IVs and Zofran and Toradol were carried out simply through standing orders?
So we have a set of standing orders that, with the SOPs and or standing orders, they had inclusion and exclusion criteria. Medications such as Zofran and Toradol required additional approval. There were certain exclusionary criteria that had to get escalated via a phone order from the physician or further evaluation. And there were even some that required the patient to go with their primary care provider to get them to sign off on it. Or anybody that potentially would have been pregnant, they, like, for an example, would have to go see their OB to get them to sign off on it. So there is definitely collaboration before any orders could be necessarily given to any patient.
Was it your practice to try to achieve a specific order, a specific patient regarding Zofran or Toradol if they requested it?
Yes, based on the inclusion and exclusion criteria.
Did you have any ability to intervene on behalf of a patient at a home if there was any kind of emergency from this administration of an IV?
Yes, so I had access to the IV, I had access to epinephrine. Also, I could call 911 and contact the medical director. In addition to that, I am BLS certified. I'm an instructor for BLS, ACLS, and I also work on the local fire department in addition to my nursing skills. I am an instructor for BLS, ACLS. I work as a nurse and on the fire department.
I'm going to show you exhibit, I'm not sure the exhibit number, I apologize. It's actually pages 11 and 12 of the documents. Can you read that statement for me here?
It is recommended that medication orders be patient condition specific to take away the notion of the nurse prescribing medication.
When you read the words recommendation and notion there, what does that suggest?
That there's a very gray area and it's not necessarily required.
You're being charged with violating a rule. Do you understand what you're being charged with violating? What rule you're violating? Or is it a recommendation?
It's according to that, it's a recommendation.
Did you know that the Arizona physician, did you know that he had not satisfied the 75-mile locality rule here in Mississippi?
I was not aware of that until we received discovery Thursday.
But you did not personally reach out to the Board of Medicine and ask anybody to verify that the Arizona physician was complying with all needed Mississippi rules?
No.
Do you know anything that would require you to use it?
I do not.
Anything else you'd like this board to know?
Yeah, so with that, as far as the physician, I would like it to be known that IDRIP was well established within the state of Mississippi before I ever decided to initiate a brand and operate underneath them. So I had no reason to be concerned that the physician or the people operating within the business were operating outside their scope, or he didn't have justifiable standing orders. Like I said, I have strived since the incident in Alabama to make sure I'm operating within my scope entirely, no questions asked. And kind of case in point, when IDRIP wanted to expand their services to include some aesthetics, I knew that typically requires additional certification. and additional practices. So I escalated that concern to the board and found out that RNs cannot do it in the state of Mississippi. So I actually escalated that to IDRIP as soon as I found out about it and told them we would not be able to include that in our services.
One second, Your Honor, I may be done. Did you ever encounter or speak to Ms. Priscilla Burks with a board of nurses?
Yes, she's the one who I was mentioning just a moment ago in regards to aesthetics. So when I actually reached out, I received a response from Priscilla Burks.
So you did contact the board in an attempt to clarify what was permissible and what was not.
Correct.
I noticed that in Ms. Jones' questioning that there's no notation here as asking you whether or not you did contact the board, is there?
No.
Okay, but that is in the charging document, says you did not, right?
Where?
In the charging document, it says, can you read here for me?
Responded not check with the Mississippi Board of Nursing Licensing Board to ensure compliance with nursing standards or nursing scope of practice.
But there's no question about that issue reflected in these notes that Ms. Jones created, right?
Correct.
And you actually did contact the board,
Correct.
and that was, you contacted who?
Priscilla Burke.
Cross-examination.
Yes, thank you, Your Honor. Mr. Oglesby, you said you, were licensed in 2014, is that correct?
2015,
2015, apologize. Where'd you go to school
East Mississippi Community College,
at? Where are you currently working now?
Medical Solutions.
What is that?
You can see,
What do you do there?
I'm an ER nurse.
Where have you worked before you were at, Medical Solutions? Where were you at before that?
I believe I was working with Freedom Healthcare.
What's Freedom Healthcare?
It's a nursing agency.
Is that travel nursing?
Correct.
Where did you work for them?
In Maine.
What was your position in Maine?
Emergency nurse.
So you've done an ER nurse twice now?
Correct.
Was that when when did you work in Alabama?
That would have been between 2015 to 2017, if I believe correctly.
So did you go from there to then, or with Freedom Healthcare?
No, I have a rather extensive resume. I don't have that in front of me.
Can you remember where all you worked?
Not necessarily, because with a travel nurse, I swap jobs every 3 months, just about.
So you can't remember where all you worked in the last, let's say, 8 years?
Not without my resume being in front of me.
Okay. Well, in the positions you do remember, what was your position?
Either ER or ICU. I did also work in as a home infusion nurse.
Did you have any issues at any of those places that you can remember? That you can't remember your other places?
Not other than UAB, I did not.
So with the UAB thing, you hit an artery, is that correct?
Correct.
How long had you been a nurse at that point?
Could you provide me the date that it said?
It's in your order that the Alabama board issued, guessing. According to the board order, they ordered this in 2021. Do you not remember when the incident occurred?
No, it would have been I think it was at least a year before that.
According to this, is June 19th. So you were licensed for 4 years? Said you were licensed in 2015.
And you said it happened in 19,
That's what the board order says.
then it would have been 4 years.
So my understanding is that an artery is deeper than a vein. Is that correct?
Not necessarily.
So is it a common practice that you could hit an artery while trying to give an IV?
Towards the distal end of the arm, yes.
Is that where were you giving this guard the IV?
Towards around the wrist.
And had you ever done this before?
Yes.
And you've never had any issues before giving an IV?
No.
Yeah, you stated earlier that you stopped, you only did this for about 4 months, correct?
The IV hydration to you, yes.
And that you said also earlier that you said the board contacted you about iDrip's business model?
Yeah, so I was approached by or contacted by Ms. Jones in regards to a complaint that she wanted to have a conversation about.
About what?
About the complaints that were put forth here today.
So so she was contacting you about a complaint, not about a business model?
So it was in regards to the complaint followed by the SOPs and standing orders. Which-
When did you stop doing the IV, working for the iDrip?
I would have to look at the specific dates, but it would be right after our meeting took place.
So after you found out you were being investigated, you stopped?
Correct.
So you also testified that you reached out to the board, to Dr. Burks,
Correct.
about what?
About adding on the aesthetics that iDrip wanted to add.
So you did not contact Dr. Burks about any of the IV hydration that you were charged with in the complaint?
No,
Did you reach out to anybody at the board to see if it was in the scope of practice to do IV hydration as an RN?
no, because they were already established here and nursing was performing the duties.
Are you familiar with Part 2820, or I'm sorry, Part 2830 in the admin code? There is the rules and regulations of nursing. Are you familiar with those at all?
I do not believe so.
What's the rules and regs for your license? And so I guess my question is, you were charged with essentially pricing outside of your scope and not meeting the acceptable standard of care, correct?
Correct.
That's kind of a summation that may not be fair. I mean, the charges are very specific. They seem to be based on things that are very evil. But that's my objection. That doesn't fairly sum up the charges, ways to charge.
I can rephrase, Your Honor, and I apologize. Charge one of the complaint was charging you with practicing outside your scope, correct?
Correct.
And then if you look at charge 3, it says practicing in a manner that fails to meet generally accepted standards of such nursing practice. Is that correct?
Correct.
So part of your rules in 2830, were you aware that it requires that that the RN is responsible for making decisions that are based on knowledge, competency, and experience? Were you aware of that?
I was not aware of the rule.
So these are the rules governing your license.
Okay.
We're aware that it also says that the RN shall be responsible and accountable for knowledge and compliance with laws and regulations governing the practice of nursing.
I'm not aware. I have not read the rule.
Well, what I'm getting to is the last requirement is that you're responsible, the RN's requirement for practicing within the scope of practice is established by the board. So part of your rules require you to practice within your scope, which is exactly what you were charged with, correct?
That's what it says.
And you verified that you did not reach out to the board at all to see if it was within your scope of practice.
Because it was already established, and performing IVs and having orders is what is done on a day-to-day basis.
So well, you assumed that because it was already established, it was okay, and you didn't check with your licensing board.
So as an example, if I go to work at a hospital and I have standing orders that are set up by a physician, I would not contact the medical board either to determine if he has set up his protocols appropriately.
I'm not asking about anybody else. I'm asking about you. I'm not asking about a doctor. I'm asking if you checked with your licensing board to make sure what was done was appropriate and what you were doing.
Being that it is mimicked day-to-day activities, I did not see any reason to escalate the IV hydration to the board. And there was something that I knew that required in most states to have additional certification or training, I did immediately escalate that to the board before ever bringing it close to my brand.
So this was, you compared, you said standing orders at a hospital, right? So it's normal procedure to have some standing orders at a hospital.
Correct.
So do you think this business model is the same as a hospital? Or, I'm sorry, let me rephrase that, because that's maybe not a fair question for you. Is what you were doing the same scenario as a hospital?
Let me object to one question. I asked if we can put some parameters on that.
I can rephrase it if that's.
Sure, if you can rephrase it or if you can repeat it.
Is this iDrip, I'm sorry, hydration to you, what the business?
Mhm.
Was it a similar operating or similar in operation to a hospital?
So if people come into the infusion clinic at a hospital, or they come into a emergency room, for example, and they think that they're dehydrated and the assessment aligns with such, then yes.
Who's assessing those patients?
So I perform a nursing assessment. I know that needs to be delineated from based on what's been spoken about. There's a complete difference between a nursing assessment and a physician assessment. So at the home, I perform the nursing assessment. I perform vitals. I look at cap refill, mucous membranes, everything. Look at exclusionary criteria such as rails and edema, all those things.
So when in this iDrip, I guess what I'm getting at is when is this hydration to you? When is a physician assessment? Or when is there a medical assessment period other than a nursing diagnosis?
So that is, once the intake form is complete, it's pushed over to the physician.
But did the physician ever see the patient? Because in your statement, you can answer. Go ahead, I'm sorry.
So as far as the physician, when the intake form's done, he sees what they want. He looks at inclusion, exclusion criteria based on the intake form. And then they would give me the okay to proceed.
But so the physician never actually saw the patient. Is that correct?
I don't believe so, unless there was exclusionary criteria he needed to further discuss.
So was this on these intakes forms, would they fill out the intake form and then you just went by? Or how did that work?
So they fill out the intake form and it gets put into the queue for the physician, and then it gets pushed to me.
So they just basically select what they want and then it's pushed to you and you go see the patient?
It's not what I said. I said they fill out the intake form.
Uh-huh.
It gets pushed into the EMR. And then the company iDrip pushes it to me. So at that time, I'm going to say that's where the physician looks at it. And I know we were going over the dates that the doctor finalized his charts. I can't speak to when he initially looked at the charts, but when he finalized the charts, that's the dates that you're seeing.
So that when he actually looked at the charts or all we have is what you sent us and that's those finalized. I guess that's when he viewed it. So there, some of these were way after the patient.
Well, I can't speak to what the physician did or when he officially signed off on his chart saying that they were complete.
So did you do any lab work or anything?
No, it was not ordered by the physician.
But then like these IVs were ordered either. They're just under a standing order. Because you even said first you said earlier that Zofran and Toradol, like those had to be specialized.
Correct.
But in your other statement with Ms. Jones, you said that standing orders only for all services. So which is it, I guess?
No, so there's standing orders, and then there are certain things with, like I spoke to earlier, that there's inclusion, exclusion criteria and certain medications that required physicians sign off on. Certain patient populations required physician signature on everything. So it's all based on the SOPs and standing orders that the collaboration between the two physicians and pharmacy put together.
So was it, I guess I'm getting confused. So was there just a general standing order period?
So a part of the SOP, there's the standing order with inclusion and exclusion criteria. Anything that had what met exclusionary criteria had to turn into a patient-specific order, whether it be written or a telephone order.
So I guess I'm not following you. Let me ask you this way. You've been a nurse now since 2015, so 9 years. Is it okay to have a general standing order for the general population?
Object, one question that calls for a medical legal conclusion.
You've been an RN for 9 years. He should be able to give a medical opinion, whether you can have a general order for a general population.
Objection is overruled.
But once again, I don't create orders, so
Okay, is it a normal standard, is it standard practice to have a general order for a general population? Not defined through anything.
so typically with indications. So if someone is dehydrated and they meet these inclusion criteria that would be set up by the prescribing individual, that's the inclusion criteria. And if they did not meet any exclusionary criteria, they would become a candidate, but it would still have to be pushed over to me by the physician.
So, but it sounds like you're saying you need a specific order for that because they all have to be assessed based off any lab values or signs or any, you keep saying inclusion. Right, so you would need a specific order depending on what that person presented.
So once they do the intake form, it gets pushed to IDRIP and then pushed to me. So with IDRIP, there's the physicians that review all the intake forms to ensure that it's appropriate intake or inclusionary or exclusionary criteria are met.
So you got the orders, I guess the orders are coming from, how did you get the orders? Was it just a standing order that was issued or did you have to meet this protocol?
So it's the standing order with the standards of procedure. The patients would do their intake form based on what they wish to receive. At that point, it got pushed over to IDRIP. I didn't get the okay to proceed until it came from IDRIP. So my understanding of how the procedures all worked is that it's been evaluated by the physician, pushed to me, and the standing order is okay to go ahead with.
So was there any medical justification for any of the IVs that were ordered that the patients picked? Because I mean, it literally says, and there's several things, you pick what you want. There's even a Facebook post, or I'm sorry, social media post, it may not be Facebook, that says, here's our full menu. Please reach out if you have any questions.
Yeah, so the menu correlates with a menu of service correlates with standing orders. Just because you select something from the menu does not mean you automatically receive it. So, and just like at the hospitals now, they have to put out their menu of services, what the service is going to cost. You have access to these services, but they have to be prescribed by the physician.
Right, so I guess where I'm getting at is where was the medical justification for these? So if a person is just saying, I feel dehydrated, you didn't perform any labs, you didn't do anything, you just showed up, correct?
Correct.
But you stated earlier, I guess I'm not understanding, because you made several different statements, that you assessed them and gave them what they needed based off what they wanted.
Once again, there's a difference between a nursing assessment and a physician assessment. And the medical justification would have to come from Dr. Feinzheimer, because he's the one who pushed it to me.
Right, so you would go after you got this?
Correct. The intake form goes to IDRIP, and then IDRIP pushes it to me.
So why are you doing a nursing assessment if it's already been done if it's already been a medical assessment by the provider?
Because a nurse shouldn't do any interventions without performing their own assessment.
But we don't have any of those assessments anywhere, is that
We
correct?
do. Every SOAP form is a nursing assessment.
But there's no lab values or anything.
If the physician didn't deem it necessary to run labs, and he bases that on, I was assume the exclusionary criteria, like the individual that did not end up getting Toradol, she had a prior kidney issue, which is filtered through the kidneys. So in order for her to get signed off on it, I'm assuming she would have had to get labs.
Did you, but you don't know if she got labs or not?
No, I was not involved in that.
So you just showed up and gave her an IV?
Correct.
You did say you did home health, is that correct?
Correct.
So do you have specific orders for your patients there?
Correct.
And they were specific to that patient, correct?
Correct.
Was that different than this business model or what you were doing with this hydration to you?
It was.
Okay, because it was specific to that patient?
Yes, it wasn't exactly IV hydration. It was IVIG.
And you weren't operating under any standing order, right?
No, those are patient-specific orders.
So I guess there's been some talk on this too. When these IVs were mixed, because I mean, it's very evident that people could pick what they wanted. Not say they didn't pick Toradol. Say they picked Trimino, lactated ringers. Oh, boy, I can't say half of this. Let's go with these ones: alpha lipoic acid and B12. How does that get in there?
So we follow the standards of procedure. We have a certain order that we mix it in, a certain way that we poke the vials, and then put it into the bag.
So you put it in the bag once you got there?
Correct.
No further question, John.
Mr. Oglesby, are you glad to be done with IDRIP?
Absolutely.
Any questions from the board for this witness?
Hi.
Thanks for coming and being patient with us as we're trying to understand the process that you went through. So I have several questions and I'm going to try to put them as chronologically as I can so that we can walk through it. So how did you find out about IDRIP?
So I actually found them out through marketing. And then yes, that was initially, I think it was a Facebook ad that I picked up on, and I did my own looking into the market. And then actually I called around to the different people that were in the state already to see how they were operating and made sure that my territory was available essentially from a business perspective.
And IDRIP gave you that information?
Correct. So initially on their website, it actually showed all the states that they cover. And then when you click on the state, it would show everyone that was in the state operating underneath them.
And did I hear that your testimony was that you did not receive any information on any patients until after a physician had reviewed the intake and then that intake was released to you or your brand or however?
Correct. The only time that I would have known about it beforehand is if they contacted me and I would refer them to the intake form or give them the link, and then that would be submitted to IDRIP.
And then, so where are the medicines kept that you would be responsible for giving and the IV fluids?
Yeah, so they're kept in, basically, they were kept in my home. They were shipped to me from the pharmacy. So the orders were placed with iDrip. The doctor would sign off on the quantities and whatnot, and then they would ship it to my home. And then it was vials and LR bags, essentially, along with the supplies. And the storage requirements were basically room temperature for everything.
So you received it per patient quantity or you received a bulk?
So I received it in bulk, and whenever the stuff got pushed, we would pick from the supplies.
Okay. Did you ever personally talk to the physicians?
Yes, in the beginning, I talked to the CEO, the CFO. I spoke to the physician in the beginning. I spoke to our compliance team. Spoke to everyone. And then we were specifically told, being that he was covering such a large number, not to contact him unless there was a problem or you met exclusionary criteria.
Okay, so let me back up with that. So that's the beginning, right? I understand that from a business perspective. So from a patient perspective, if the intake goes to the physician first and then is released to you and you get to the patient's home and do the vital signs.
And there was like an outlier that would be deemed an exclusionary criteria. I'd have to escalate prior to administering.
So you never had an exclusionary
I did not.
criteria in 4 months?
No, luckily I did not.
Okay. So as far as the your testimony was epi that you kept for adverse reactions?
Correct.
Is that the only medicine that you kept?
That and IV fluids. So just those two. There was discussion about Benadryl, but they were concerned about people's addiction to getting the IV push of it, so they didn't want to have that on hand.
So you didn't give anything, nothing was precautionary like orally or anything?
No.
I think my last question is, what are the dosages of Toradol and Zofran that was released to your home?
So it would have been the 4 milligram vial and the 15 milligram vial.
So those are the only dosages that you would ever give?
Yeah, but I never gave them. That was what I had on hand.
And you don't have that business anymore? Do you still have those medicines?
I do not. It's been so long I had to dispose of them. Okay.
Thank you.
Additional questions?
We got a couple of questions for you, okay? So I'm trying to get an understanding here, and I don't mean to keep on, but so iDrip was a parent company, and then you created IV Hydration to You LLC to go under that company. Is that correct?
Correct. So essentially it was a brand under their umbrella.
So did you work for IV Hydration to You, or did you work for iDrip?
I worked under IV Hydration to You, but I was contracted with iDrip.
So your company that you created contracted with iDrip. Okay, and so you worked as a registered nurse. And I believe you said, so I know that your filing that's in the record here showed that IV Hydration to You was created in October of 22. When did you dissolve that?
I would have to go back and look at it. I'm not sure of the actual date.
But you only practiced under this entity for 4 months, correct?
It was a very short time.
So for 4 months. So we're probably looking at February of 23, possibly. January of 23. Is that the last time you've practiced as a mobile hydration nurse?
Yes.
So essentially, IV, what was the business structure? How did you set up IV Hydration to You with the Secretary of State's office? What was the business structure you set it up under?
So I set it up under basically the LLC, but it was essentially just as a brand. Like that's all it was, because everything was housed with iDrip. from like the contract, the certificate of insurance, like everything, the way they had it set up, it was all an umbrella for us.
So when you went in to create the filing, what category did you put your business under?
I believe it was health and beauty, I believe, maybe.
So let me ask you this. So essentially, IV hydration to you was functioning as a home health somewhat. You went into the homes, you provided health care under a doctor's order. That's what I'm understanding.
Correct.
So it was a home health. So was it approved by the State Department of Health? Do they have any knowledge of it?
When I inquired of that, well, I inquired about that with iDrip, and they said everything was kosher, ready to go. I asked them numerous times. They had legal involved, compliance involved, and I never had a reason to suspect otherwise.
But you agree it probably would have been a good idea since your company was providing home visits
Well,
for the Department of Health to be involved.
site is 2020.
Sure.
Yeah, which is exactly why I stepped away as soon as I found out stuff didn't appear to be kosher.
So let me ask you this, nurse to nurse. What was your comfort level for working for a physician that was across the country? Were you comfortable with that situation?
So based on the orders that we were implementing or I had access to, I was, being that my primary background has been ER, ICU, and home health prior. I felt very comfortable initiating IVs, and the water soluble vitamins essentially is what I was giving. There,
Was Dr. Feinsheimer available via telehealth or any other means during the procedure? So if you had issues,
yes, so I had access to his phone number. It was his emergency line, available 24 hours a day.
you ever have to call him?
I did not. I never had any adverse events.
You know if he held a Mississippi license? Yes, he does hold a Mississippi license.
And I was reviewing my records from the CEO when I was with my conversations. There were 2 medical directors, and he was the one covering Mississippi. He was the only one licensed here.
So I heard you answer Dr. King and saying that they sent you bulk meds for you to house at your house.
Mhm.
And so we're going to say February of 23 for lack of sure knowledge. When you stepped away from the company in February of 23, did you feel that you should have sent them back to the pharmacy? Was it proper for you just to dispose of them? How were you able to prove that you disposed of them?
So the issue, it's a very complicated issue because when all this happened, when I broke ties with iDrip, they stepped away and they didn't answer any phone calls. So I had no means to send it back to them, essentially.
All right. And since February of 23, you've been working contracts as ER ICU nurse.
Correct.
You haven't had any issues?
Not at all.
Today, where are you employed?
I'm with Medical Solutions in New York.
My last question goes back to what I was asking earlier, the question I was asking earlier on the resident who requested port. And I heard your testimony and I understand. But there's just some conflicting things on here that I really don't understand. First being that in the documentation, on page 74, if you want to look there, or if you don't, I assume it was the intake is where she had requested. I'm not sure if this had been sent to you or not. I heard, was it Was it your testimony to the investigator when y'all met that when someone fills out the intake, that serves as the order? So I heard you say that they fill out the intake, goes to iDrip. I'm assuming a doctor looks at it, returns it back to you, and that's considered your order.
Correct.
So, so were you able to give this infusion to her?
I was able to give her the Myers cocktail.
Because I'm looking on page 1 of 2 of the order, it's on page 74. It says that you had a failed attempt, unable to thread catheter. But then we go on down and it shows that you had given the medicine, that she said she had relief from her migraine headache. Was she able to receive the infusion?
Yeah, so it looks like it would have been a second attempt on the IV.
And is there a reason this is the only one of the 10 that doesn't have a physician's signature on it?
I'm guessing that he hadn't finished or finalized his charts by the time I printed these. And then I didn't have an opportunity to go back because I lost access to the application.
Additional questions?
I have one more question. I'm sorry. Can you walk me through your typical practice during this time? After you received the orders and you evaluated the patient, they got their medicines, then what?
So I would be with the patient approximately like 30 minutes afterwards, look for any adverse events, recheck vital signs, finish up documentation, make sure that their IV site wasn't gonna bleed out when I left. Wrap it up, finish documentation, submit it back to iDrip. And then I would see if there's anything else and stuff, send it to iDrip. And then pretty customarily, I would have contact with the patient later on to make sure that they were doing good for both from a nursing perspective and a business perspective to see if we needed to have like recurring services. How are you feeling, et cetera? Did it work out for you?
What does later on mean?
Like if you say, if you needed like another visit, if you felt like you may need another visit like a month down the road, somebody who is getting like recurring migraines, did it work out well for you versus your standard therapy? Is it something that we need to maybe talk with the doctor about incorporating more routinely, or to collaborate with your primary physician about incorporating this versus adjusting your other meds?
Okay, so that's like a month afterwards, but was the patient, did they receive any sort of discharge instructions or risk benefits or how to contact or
Yep.
what they were supposed to do after?
So let me look real quick. So the consent form here kind of goes as over potential complications, stuff like that. I also did my nursing part of like what to look for. If you have any of these issues, feel free to call me and I'll get the medical director on the line. And like what to look out for essentially. And I would be happy to come back or call 911, do whatever we need to do to make sure you're okay. Yep.
I just have one question. How did you go about obtaining your collaborating provider? Was this a provider that already had a relationship with iDrip, and that's how you?
Correct. So it basically, my business contract with iDrip came as an all-inclusive package. Like it was already established. I literally bought in to basically to have the rights to utilize their services. I had access to the physician that was dedicated to Mississippi. So everyone in Mississippi had him as the physician.
Any other people? Any follow-up from council for the parties?
There you go. There you go.
Gatlin, do you rest this time?
Yes, sir. Arrested.
All right, now we're closing statements. Begin
Thank
with-
Thank you, Your Honor. Mississippi Code annotated 73-15-29-1 provides that the board has the power to take disciplinary action on a license of a nurse if that nurse has violated the rules and regulations governing nursing. Mr. Oglesby practiced outside the scope of his RN license by mixing and administering IVs. By doing so, whether inadvertently or not, he endangered the public. No lab work was done before the IVs were administered. A physician never actually saw the patient to provide any type of medical diagnosis. Patients merely selected the IV they wanted and were allowed to add different drugs to the IV. There was no medical justification for the administration of the IV. Mr. Oglesby's also testified that he mixed these IVs and prepared them for the patients. On top of that, Mr. Oglesby has had prior discipline while attempting to start an IV. Further, he never reached out to the board to ask any questions before beginning IV hydration. And as required by the rules, RN is responsible and held accountable for their actions to make sure they're practicing within the standard of care. And to accepted standards of practice. For his violations, we would respectfully ask this board panel to consider taking disciplinary action on license, Mr. Oglesby. Thank you.
I think it's apparent that this exploding business model that all of a sudden is all over the country, hydration, is giving problems to boards, nursing, boards of medicine, and nurses all over the country. And so we're not unique, you're not unique in that way. And I appreciate that, client does too, all too well. I think that you can see there's an underlying gray area here where the charges are all undergirded by the statement that determined whether or not he was going beyond the bounds of his nursing license. When that standard said it recommended that these medication orders of this type be patient condition specific. Recommended won't work in a court of law. It shouldn't work here. You know, put yourselves in his shoes. And this almost looks like, if it was a criminal indictment, it almost looks like overcharging. It's 7 different counts that all concern the exact same thing. They're trying to make it sound like Mr. Oglesby killed somebody. And the 7 counts are all supported by this language, which is so ethereal, that says it's recommended so that he doesn't give the notion that he's overstepping his bounds as a nurse. And as nurses, you should resent that. It's not fair. If that standard was turned on you, you wouldn't like it. So I would suggest that given this new business model that's giving everybody trouble, the best course is not to lambaste and punish an individual nurse who got involved in it, but possibly pronouncements, statements, rules governing this explosion of different companies that are trying to present these services, so that nurses are informed ahead of time what's kosher and what's not, rather than some statement in an indictment that says it's recommended, that you don't give the notion that you're overstepping your nursing license by not doing these things. Those kinds of recommendations don't sufficiently undergird and prove 7 charges of this magnitude. Nobody was actually injured. We know that. There's no proof that he ever gave anything like Toradol or Zofran, any things that are alleged. Anybody? There's just not enough here. And I would ask you to dismiss these charges or find them insufficiently proved, or at the most, take into account how vague the underlying rules are here, and look more to education, statements and policy statements to the board than to lambaste a young nurse who's being very honest.
Thank you. This concludes the hearing in case number 2022-0887. In case number 2022-0887. The people will make a decision today and announce that decision today. So you can wait for the oral announcement or wait to receive the written final order in the mail. It's totally up to you. Mr. Walker and Ms. Salzman, I understand the board wants to take up some voluntary surrenders, so I'm gonna call them. Do you have them ready for them to take back?
And you're on. Back forward.
Honor, we would ask that voluntary surrenders be considered in case number 2022-1007, Jacob Hale. Case number 2023-0827, Stephen Williams. Case number 2022-0436, Stacy Rawson. Case number 2022-0353, Sherry Harris. And case number 2023-0905, Amber Smith.
Thank you. At this time, I'll entertain a motion from the board to go into closed session to determine whether grounds exist to go into executive session to deliberate on case number 2022-0887, 2022-1007, 2023-0827, 022-0436, 2022-0353, and 2023-0905.
Make a motion, we go into closed determination session to determine if executive session is needed in stated cases.
I'll second.
All in favor? Any opposition? Hearing none, at this time, I'll entertain a motion from the board to actually go into the executive session to deliberate on the stated cases.
Make a motion, we go into executive session for deliberations on stated cases.
Second.
All in favor? Any opposition? Hearing none, the board is now in executive session. members of the board hearing panel to state their names for the record.
Jeremy Cummins.
Melissa King.
And now I will announce the board's decision in case number 2022-0887. The board finds the licensee guilty of all charges. The penalty imposed is a restricted license. The license is restricted for 12 months. Within this time period, a formal reprimand will be issued, a $500 fine, single state license, and education to include 15 hours, a 15-hour course in ethical decision-making, a 6-hour course entitled Legal Issues for Nursing Documentation, 4-hour course upholding the standard, and a 2.5-hour course, parts 1 and 2, bringing the nurse scope and standards to life. And lastly, prohibited areas of practice, no private duty, home visits, or hospice during this period, 12-month period that your license is restricted. Final order will be issued within 30 days, consistent with this announcement. Do you have any questions?
No question.
Thank you. This concludes the hearing. Yes, and on the voluntary surrenders, all were accepted, and here they are now.
Ready to go? Yeah. Good. We are.
On the record. And I ask the members of the board here in panel to state your name.
Jeremy Simmons.
Dr. Melissa King, nurse practitioner.
All right, next up on the docket is case number 2023-1095. Ms. Kirsten Griffin.
No, Your Honor, we continued that and I apologize.
Oh, okay, I got it. No, Dee told me that. I didn't know if we were gonna do something officially on the back. I don't know if the next matter on the docket, Amanda Harmon, 2023-0650.
Yes, Your Honor, we would ask that exhibits B1 through B11 be admitted into evidence today. Mrs. Harmon was served with a notice of hearing a complaint. You will see on pages 9 through 11 that she signed for that, and there's a certified mail receipt showing that delivery was perfected at 909 Peppertown Road, and that matches what you also find as the address that she's entered in her gateway on page 2 of the proposed exhibits. So the board has satisfied statutory service of process. The board has heard nothing from Mrs. Harmon since she received this complaint, either requesting a continuance or requesting anything in relation to this case.
Thank you. It appears that Ms. Harmon received statutory notice of today's hearing and has not provided any reason why she cannot attend today. So we will proceed with the hearing in her absence. Any preliminary matters?
I would just request that B1 through B11 be entered into evidence.
Yes, so admitted.
And I would also request that would be allowed to rest on the file.
That's fine as well. Next up on the docket is case number 2022-0811, Mr. Jordan Boylan.
Yes, Your Honor, we, Ms. Bolin was sent her notice of hearing in December. You're seeing the exhibits I plan to introduce that came back, returned to sender. It was unable to be delivered. So we couldn't get service by certified mail. So also in the exhibits, we published her as required by statute for 3 times. We have an affidavit showing that she was published to be noticed for today's hearing. She has not shown up and we have not heard anything from her requesting the continuance. And so the licensee is not present today.
Thank you. It appears that the licensee received statutory notice of today's hearing and has provided no reason why he cannot appear on his behalf. So we will proceed with the hearing in his absence. Any preliminary matters?
Yes, Your Honor, I request to enter into evidence B1 through B7.
So admitted.
And then I just request the rest on the file, Your Honor.
That is acceptable. And now I'll ask the board, how many of these ASBs?
We go off the record that just a second on the AFC.
Yes, we're gonna take a 5-minute recess and return at 3:10.
I just had a quick question for court.
closed determination session to determine if executive session is needed for case numbers 2023065 and 2022-0811.
Is there a second?
Second.
All in favor?
Aye.
Any opposition? Hearing none, I entertain a motion from the board to actually go into executive session to deliberate on the stated cases.
I make a motion, we go into executive session for deliberations on stated cases.
All in favor?
Aye.
Any opposition? The board is now in executive.
Back on the record.
We are back on the record. I will announce the board's decision in case number 2023-0650. Licensee is Miss Amanda Harmon. The board finds the licensee guilty as charged, and the penalty imposed is revocation. Case number 2022-0811, Jordan Bowling. The board finds the licensee guilty as charged, and the penalty imposed is revocation. We will take up the next matters on the docket. Case number 2023-0510, case number 2022-0254, case number 2022-0222, case number 2022-0023, case number 2022-0107, case number 2021-0862, case number 2019-0590, and 2022-0763, case number 2022-1007, and lastly, case number 2022-0206. This time I'll entertain a motion from the board to go into closed session to determine whether grounds exist to go into executive session to deliberate on these cases.
Make a motion, we go into closed determination session to determine if executive session is needed for deliberations on stated cases.
A second. All in favor? Any opposition? Here. Session to deliberate on the stated cases.
I'll make a motion, we go into executive session for deliberations on stated cases.
I'll second.
All in favor?
Aye.
Any opposition? Here none. Session.